from supplementary list for admission item 5, WPC 3265 of 2023.
They have filed the rejoinder.
Yes, Your Lordship, they have filed.
What are they stated? What have they stated in the rejoinder?
Your Lordship, they filed two rejoinders, one for the state counter affidavit filed by the state and one for the counter affidavit filed by the Honorable Governor.
What is their stand?
Yes, Your Lordship.
What is their stand?
Your Lordship, they have brought the notifications relating to right to fair compensation and provisions of PESA Act, Your Lordship, on record. However, Your Lordship had directed them to bring the copy of the notices
You
with
were
their.
supposed to bring.
Your
Where is the
Lordship,
state council?
I am not for the state. Your
State
Lordship.
council was supposed to bring it.
Yes, Your Lordship.
Where are they? Counsel for the petitioner and the state is absent. The learned counsel representing the Honorable Governor is present. Post tomorrow. If the state does not appear tomorrow, we'll call the chief secretary in the court. Please.
For hearing item 6, second appeal 251 of 2017.
Appellant. Where is the appellant? Mr. Anil Kumar? ये मिस्टर केपी देव के ऑफिस का केस है। आपको कोई चिंता नहीं?
हाँ, देख
चिंता
लेंगे।
होनी चाहिए ना आपको?
जी।
क्या करना है इसमें? डिस्कस कर देते हैं।
नहीं, हुजूर देख लेते हैं।
Last night, MS Vani Kumari was appearing. And at
we
her
can-
instance, the case was listed today
My
in
lord,
the
I will
supplementary
take
causes.
myself.
Today she is not appearing.
I will take myself.
आज हम इसको adjourn नहीं करेंगे, या तो DLG कर
अभी
देंगे,
अभी हम देख लेते हैं. I will see.
pass over 12 बजे आएंगे.
My.
अपने सरिस्ता का केस का ध्यान रखिए भाई.
Obliged. Certainly.
थोड़ी है,
Highly obliged.
ध्यान रखना है आप लोग को.
Lords.
लिटिगेंट है ना, उसको हार्म नहीं होना चाहिए किसी
My.
से. आप लोग का पूरा टीम है, we know
जी,
everything.
जी.
तो ऐसा कुछ नहीं है, आप लोग अपना देखिए.
I will take other cases also in.
हाँ, yes, you should
Lords.
take up.
Lords.
क्या है, आपको असिस्ट करना है.
Sure.
थोड़ा जरूरत हो तो लिटिगेंट से इंस्ट्रक्शन ले लीजिए, यही हो सकता है.
My.
You are there in this case.
Lordship, I'm so sorry, Lordship. Item number 5, Your Lordship, it's just
What is item number 5? यही कॉल हुआ था.
supplementary.
Item 5 tomorrow.
Lordship, they-
कल अगर आप नहीं आएंगे सुबह, हम चीफ सेक्रेटरी को बुलाएंगे.
As this, Lordship.
Very good. We do not know.
Lordship,
कल-
supplementary we have to file, Lordship.
Yes,
Seek
you
for
file
permission. We seek for permission, Lordship, I just-
You just seek permission. You file whatever you have to file. There is a response filed by the petitioner. Right? They have filed a counter affidavit.
Rejoinder.
Rejoinder. Yes.
Notification, Lordship, we were asked to bring this to the property.
We do not know. Don't come after the case, after the order is dictated. You come tomorrow and be here at 10:25 itself.
From daily list for order benefit item 2, second appeal 691 of 2016.
May I tell you? Lord, I have filed two items. One is for the defect number 1, my lord.
What is it?
Defect number 1 is, my lord, pointed out void SR dated 4/12/2023. Suit value of trial court decree and appellate court decree differs, my lord, for which I have filed, my lord, instant interlocutory application to send back the court below the decree for the correction, your lordship.
What is the other IU?
Obliged, my lord.
What is the other IU?
Other IA is in respect of limitation, my lord.
देखिए
There
IA
is
number
delay in filing
740.
136 days, your lordship.
IA number 7408 of 2020. In SA number 691 of 2016. Council for the appellant submits that the decree of the appellate court.
Decree, suit value of trial court decree and appellate court decree differs.
किसको भेजे हम?
Court below, my lord.
कौन सा भेजे? appellate court decree भेजे कि trial court decree भेजे?
My lord, appellate court decree.
The
My
learned counsel for the appellant submits that the appellate court decree
lordship.
be sent back to the concerned court for correction. Considering the submissions, that the appellate court decree be sent to the concerned court for correction. उसमें एक चीज और the suit value has been wrongly mentioned in the appellate court decree. Are you disposed of? There are other defects to be cured.
Yes, my lord. I have all removed all the defects.
Pose this case on March 27th
Obliged.
under absolute.
Item 3, first appeal 105 of 2022.
May I
But then,
Take for time,
time for what?
time for the defect review along with the deposition of the because I was engaged in my mother.
Sorry?
मेरी माँ का देहांत हो गया था कल हम इस वजह से हम नहीं कर पाए
कोर्ट फीस जमा करना है ना?
हाँ वो एंड सम नॉर्मल
कितना टाइम चाहिए?
4
FA number 105 of 2022. Counsel for the applicant pays for and is granted time till 28th of February to remove the surviving defects present. If the defects are removed within time, post this case on 5th of March.
Item 4, first appeal 319 of 2023.
Nobody appears on behalf of the applicant. Same order.
Item 5, first appeal 68 of 2024.
Same order. Nobody appears. So, I open the file once for ignoring any difficulty. Check करना हमेशा.
For hearing under order 41 rule 11, item 9, second appeal 376 of 2019.
Case to be missing findings, my lord.
What's the suit for?
For right, title and interest and confirmation of possession of the disputed one land, my lord, which is homestead land. And it is said land. The said land was purchased by the plaintiff's my lord. And it goes back to one who substituted Khalifa, who had sold it to his wife, and then she died with two heirs, my lords. One son and one daughter. It is said that the son sold the lands to the father of this plaintiff, my lord.
Were you able to prove your case?
My lord, in the trial case, yes, my lord.
Yeah, further.
For respondent.
The case has not yet been admitted.
Kya?
Case has not yet been admitted.
Not yet admitted. But according to me, till now, whatever has been said with regard to the right of the respondent by the courts, there is no judgment which says that the respondent would not have any right to argue at the time of admission. I don't know.
Certainly,
Your
assistance is
Lordship, there
required
was
to frame the question of law. I don't have any issues, but I just wanted to know as per the procedure followed.
No, why Your Lordship may see, because this is a question which regularly crops up, and Your Lordship may see section 100. It only says what Your Lordship may see, because time and again this crops.
Like it is.
And there was, I remember, but directly there is no judgment. I must admit that directly there is no judgment. Section 104 first, that where the High Court is satisfied that a substantial question of law is involved in the case, it shall formulate that question. The appeal shall be heard on the questions formulated, and the respondent shall at the hearing of the appeal be allowed to argue that the case does not involve such question. But merely because of these words, it does not say that at the time of framing of the question itself, the respondent would not have any right whatsoever. It does not say so, because the orders are in my
We will
favor.
decide in one case if there is any objection. see, at the instead of respondent objecting it at a later stage, a case can be taken care of. The question of law can be taken care of because it is for the court to formulate the question of law. Ultimately, it is not for the appellant to formulate the question of law. It is the satisfaction of the court with regard to formulation of question of law with the assistance of the appellant. And later on, you have a right to object to the nature of question of law. And subsequently, we are coming across circumstances where it is submitted by the respondents that this particular question does not arise.
Absolutely. So no, there was no question of
You have
allegation.
entered appearance by filing locality.
Correct.
We will hear you, don't worry. Because when it is my satisfaction, then I have to see that whether I am satisfied with the.
And Your Lordship, I recollect, today I don't have that judgment, where the Honorable Court discussed that prior to 1976, in 1976 there was this amendment, this clause was inserted. Prior to that, this was not there. So then it was taken note of by the legislature that regularly the High Court was admitting the second appeals.
At a matter of course.
So therefore this provision was inserted. So once this provision was inserted to regulate or to restrict the second appellate jurisdiction, how can it be taken against the?
You want a decision in this case itself?
Because regularly it comes
Do you
up.
have any objection to the appearance? He doesn't have any
Then
objection. But then,
very fair.
she has always been very fair. I've noticed a number of reasons. Yes.
These plaintiffs, they came into possession and they got the land through one Ibrahim.
No, let us see the parallel rights. Okay. Plaintiffs were claiming through.
They bought it from one Muhammad Ibrahim Taylor, my lords.
Muhammad Ibrahim Taylor.
Yes, my lords. By two registered sale deeds.
Registered sale deed.
One dated 1995
1995 and other one
and the other one dated 9198.
9198. Okay.
And since then they have been in possession of the lands. They have even sold some portion of the lands to two pro forma defendants who are 3 and 4.
So, defendant number 3 and 4 by registered sale deed.
Yes,
What are the deed numbers? Date of deed. Yes, madam, why are you so apprehensive? You just relax.
No,
She is a very good counsel.
Yes, yes.
चिंता की कोई बात
Yes. That's the
नहीं. No, you be there. It's okay. पर चिंता नहीं करने का. Yes, tell me. Anyways, it was subsequently sold. Now tell us what is the right of Ibrahim Taylor? How does he acquire right?
Yes, my lords. This Ibrahim Taylor, my lords. So he has gotten it from his mother, and first, the first person.
By succession?
Yes, my lords.
By succession from mother.
Succession and adverse possession also, my lords.
From mother?
My lord, succession, and he has been the sole person possessing that land.
When you
for
say
over-
succession, where is the question of adverse possession?
My lords, because it is said, it is claimed by him that he had just one sister who was married and who lived in a different village, and she had relinquished the rights, her right to this.
Any relinquishment deed?
There is no deed as such, my lord.
No deed of relinquishment. What is the name of his mother?
My lord, Sarifan.
Zarifan.
Yes, my lord.
She had. It is a fact which is recorded that she had two children,
Yes, my lord.
Ibrahim
Ibrahim Taylor
and
and one Nasira.
Nasir. And you are claiming through Ibrahim Taylor,
Yes, my lord.
where Nasiran did not join. In
Yes,
whose
madam.
name the property?
defendants are claiming
The
through
property is recorded in whose name?
Madam, it was first recorded in the name of Shamsuddin Khalifa,
Who is he?
who is my father.
Samsuddin Khalifa.
Yes, madam.
They are claiming through Nasiran.
The defendants, yes, madam.
Defendants are claiming through Nasiran.
Madam,
She executed a registered deed.
yes, madam, that is what they claim.
Registered
But that
deed
is
must
much
have been
later.
proved, maybe much later. What is the date of registered deed?
Madam, their registered deed is madam 2000, madam, 14/10/2000
14/10/2000.
and 27/9/2000.
27/9/2002.
Yes, madam.
Who was giving rent? Ibrahim or Nasiran?
Madam Ibrahim.
He was paying rent to the state.
Yes, madam.
What the trial court has done?
Madam.
Let us see the issues of the trial court.
Yes, madam.
Issue number 4, I suppose.
Yes, madam. क्या वादीगण को वाद पत्र की अनुसूची ए एवं बी की में वर्णित जमीन पर अधिकार स्वत्व हित एवं कब्जा प्राप्त है? Yes, madam.
Where is the finding? You just read the finding. It's wrote that plan.
Madam, the findings of 4 and 5 are from paragraph number 10, madam.
Yes, I've seen that.
Is that really 90?
Yes, para number 10. You can just come to the operative part. Let us have the conclusion of the dispute.
Yes, madam. From the last line, madam, the ninth
Okay,
line.
you just read page number 12, उभय पक्षों द्वारा, right? You read that.
Page number 12.
Page, internal page 12.
पक्षों के विद्वान अधिवक्तगण को सुना एवं अभिलेख पर उपलब्ध वादीगण के वाद पत्र वादीगण और की ओर प्रस्तुत मौखिक साक्ष्य प्रतिवादी सन 1, 2 तथा 3 और 4 के लिखित कथन तथा प्रतिवादीगण की ओर से प्रस्तुत मौखिक एवं दस्तावेजों साक्ष्यों की विवेचना किया, जिसमें यह स्पष्ट होता है कि वादीगण द्वारा वर्तमान वाद पत्र की अनुसूची बी में वर्णित विवादित संपत्ति पर अपने अधिकार स्वत्व हित की घोषणा कब्जे एवं पुष्टि तथा स्थायी व्यादेश हेतु दाखिल किया गया है। अनुसूची बी में वर्णित संपत्ति अनुसूची ए का भाग है, जिसे वादीगण द्वारा पंजीकृत बिक्री पट्टा नंबर 5013 दिनांक 19/9/1995 एवं 6794 दिनांक 9/11/1998 द्वारा मोहम्मद इब्राहिम टेलर से खरीदने की बात कहा है, जो प्रदर्श D2 एवं D3 है, जिसे वादीगण द्वारा प्रतिवादी संख्या 3 और 4 के प्रदर्श D एवं D1 द्वारा वर्ष 2006 में बिक्री किया जाने की बात कहा गया है। प्रतिवादी संख्या 1 और 2 द्वारा वाद पत्र की अनुसूची B में वर्णित संपत्ति जो अनुसूची A का भाग है को नसीरन खातून एवं जरीना खातून से 27/9/2002 तथा
14/10/2000 को प्रदर्श ए एवं A1 से खरीदने की बात कही गई है। नसीरन खातून को वादीगंज के विक्रेता मोहम्मद टेलर की बहन बताया गया है तथा जरीना खातून को एक सह हिस्सेदार कहा गया है। वैसे जरीना खातून के संबंध में ऐसा कोई साक्ष्य प्रतिवादी संख्या नंबर 1 और 2 द्वारा प्रस्तुत नहीं किया गया है जिसमें यह स्पष्ट हो कि शमसुद्दीन खलीफा से उनका कोई संबंध था जो मोहम्मद टेलर के पिता थे अथवा जरीना खातून शमसुद्दीन खलीफा की
Please hold on
उत्तराधिकारी
for
थी।
some time. We have to rise. Hold on. Yes. We have to rise. And
के संबंध को ऊपर पक्षों द्वारा स्वीकार किया गया है। यह सत्य है कि नसीरुन खातून द्वारा अपने अंश की परित्याग करने की बात सिद्ध नहीं हुई है, लेकिन प्रतिवादी संख्या 1 जो प्रतिवादी संख्या 1 के पति प्रतिवादी साक्षी 1 जो प्रतिवादी संख्या 1 के पति हैं, उनके द्वारा अपने परीक्षण के दौरान नसीरन खातून के बारे में पूरी जानकारी होने से इनकार किया गया है कि वह कहाँ की रहने वाली है और उनके पति का नाम क्या है तथा प्रतिवादी नंबर 1 प्रतिवादी साक्षी नंबर 2 द्वारा भी अपने परीक्षण के दौरान नसीरन खातून के संबंध में तथा उनके पति एवं पति के संबंध में जानकारी होने से इनकार किया गया है। साथ ही साक्षी ने यह भी कहा है कि वादी ने मकान जमीन के साथ खरीदा था, जिस पर वादी
you
ने
see, the entire finding of the learned trial court is based on the fact that there was a subsequent sale and defendant number 3 and defendant number 3 and 4 are in possession of the property. Right? It is in connection with possession. What about title?
Title also, my lords, in this, these defendant number 1 and 2, they claim to have bought it from two persons, one Zarina Khatun and one Nasiran, my lords. So two persons.
Zarina Khatun is who?
My lord, her relation to this Samsudin Khalifa has not even been established.
Zarina Khatun, you say that from Nasiran Khatun they
Yes,
bought two
ma'am.
property, 14/10/2000 and 27/9/2000. It was
Nasiran
executed by
Khatun
Nasiran.
and-
It was executed by Nasiran Khatun.
My lord, both of their names have come.
It was executed by Nasiran and Zarina.
Yes, ma'am.
What happened in the appellate court? So ultimately, what is the finding with regard to title?
My lord, the trial has helped. My lord, just if I just read some lines, my lord. प्रतिवादी साक्षी नंबर 1 जो प्रतिवादी साक्षी नंबर 1 की पत्नी है, अपने परीक्षण के दौरान ये भी स्वीकार किया है कि उन्होंने विवादित जमीन कितने में खरीदा और
No, that we are not. Just tell me the finding, specific finding regarding title. There is specific finding regarding possession of defendant number 3 and 4,
Yes, ma'am.
right?
Yes, ma'am.
With respect to a portion of the suit land.
Yes, ma'am.
But where is the finding with regard to the remaining portion of the suit land, firstly? And where is the finding with regard to title in the trial court judgment?
Regarding the documents tendered by the defendants, it has been stated that although there were two executed sale deeds of the years 2000 to 2002, but again for the same thing, there is another agreement dated 2004. My lord.
I'm not getting whatever you are saying. You are talking about some agreement. There are two sets of title deeds.
Yes, ma'am.
One is of 95-98,
Yes, ma'am.
and other is for 2000-2002.
Yes, ma'am.
One is by Ibrahim Taylor,
Yes, ma'am.
son of this Samsudin Khalifa, and other is by Nasiran.
And Zarina.
From where do you get and Zarina?
Yes, this one.
It is there. She is right.
Okay.
She is right.
What happened before the appellate court? Appellate court is only talking about Zarina, Nasiran. Appellate court is not talking about Zarina. Nasiran Khatun has rightly sold.
My lord, but it is their case only that they have bought it from Zarina also, my lord.
You read para 18. Mr. Gupta, you just tell us, is there any finding of title by the learned trial court?
No,
Because
just-
it was for title and confirmation of possession both. Is there any finding of title? Is there any conclusive finding that Nasiran was nobody?
No, no.
There is no finding.
Rather, interestingly, your Lordship may see issue number 5, which was whether she had relinquished or not. The trial court strangely comes to a finding that she had not relinquished. And then also decreased the entire suit itself.
And if there is a finding that she had not relinquished, Then the consequence would be, what would be the consequence?
Consequence would be that whatever she had sold it to me, I have a title over that and possession also, which
Without any
rightly has been held by the applicant, because I am already in possession. If I would not have been in possession, then this question could have been there.
So, if we take that Ibrahim and Nasiran were two children of this Samsuddin,
Yes.
and they had sold their respective half share.
No, not half share. I have been sold 1/3.
1/3.
But yes, one confusion is still there, Your Lordship. With regard to Zarina, there is a statement, but I am not able to get as to who she was, because Nasiran absolutely clear that she was one of the daughters of Sapira, and Ibrahim Taylor and Zarina were both brother and sister. Nasiran, so they were brothers and sisters. Only one brother and one sister. But there is one statement where it has come. She has rightly pointed out that Zarina's name has come, but who is
She is the
Zarina?
vendor.
But ultimate finding is that Nasiran had not relinquished, and this was affirmed by the appellate court. Then the appellate court says that whatever she has sold, with regard to only that portion, the appellate court partially has reversed my appeal. It has only partially.
The possession of defendant number, the plaintiffs / respondents and their purchasers are entitled for a decree of confirmation of their possession over 0.61 decimal. Right?
Yes.
So the entire property is 0.61 only. The suit land was 0.61 only. Plaintiffs, they are found to be entitled for decree of confirmation of possession for entire 0.61. And Nasiran Khatun has rightly sold. Isn't it inconsistent? He confirms the possession. But the entire, what was the suit land? What was the description of the suit land?
It was said that Exhibit A, Schedule A is the entire land, and Schedule B was a part of the Schedule A over which we were in possession. This was
Where is
our
the
case, and
Where is the decree of the trial court? Decree in appeal. You have not filed the decree of the trial court. Must have.
it is there with me, but must be there on the record also. Without which, Your
Without-
Lordship, the
certainly
office
it
would
cannot become-
point out, yes. They must
Must be
they
there.
have filed it subsequently.
आपके पास है?
Yes.
इसका ट्रायल कोर्ट का डिग्री पूछ के रखिए नीचे नीचे जाता है इसको ठीक से लगता नहीं आप रिकॉर्ड में चेक We were seeking declaration in connection with item 1 of Schedule B property. Plaintiffs.
Plaintiff, they have sought declaration and they say that
With regard to which property? Schedule A.
Schedule A, and they say that Schedule B is a part of Schedule.
They have, the appellate court has confirmed your possession in connection with 0.61
Only they say that it is only for Schedule B.
Schedule B, Part 1.
My lord, it has been partly allowed. The appeal has been partly allowed.
What is your question of law? Just what is your substantial question of law?
After these two sales, after getting possession of the land and title from these two sales, my lord.
What is your substantial question of law?
Yes, my lord, that these two.
You have framed it. You refer to it.
Yes, my lord. Whether the learned first appellate court did not produce the exhibits in toto while partly allowing the first appeal in favor of the defendants herein, and has further not interpreted the documents in its correct perspective.
It's absolutely inconsistent. These two judgments are absolutely inconsistent with others. Yes, Mr. Gupta.
Yes, Your
We'll admit it on this because we have to thrash out everything. Just there's a lot of confusion in the legal.
Confusion is there. We cannot shut our eyes from that.
Therefore, on point number D, you can come any day. Tell us when you want it. We'll call for the records. You have already appeared. You are representing all the defendants, all the respondents.
1 and
What about 3 and 4? Everybody is here. You want record तो आया नहीं होगा. Or the learned counsel for the appellant. The learned counsel for the respondents have also entered appearance over. And accordingly, both the parties have been heard in connection with framing of substantial question of law.
we had appeared on notices were issued on limitations. So we had appeared.
Have appeared as notices were issued on the point of limitation. Limitation has been conveyed.
Yes,
The limitation has already been conveyed. During the course of hearing of this case, it appears that some of the documents which were considered by the learned trial court and / referred to by the learned trial court has not been properly considered by the learned applicant.
May I submit one? Your Lordship may directly admit without making any observation, otherwise it would be there at the time when we finally argue. It would appear that Your Lordship has already disclosed. Directly question of law may be
After
formulated.
hearing the
That would
learned
be
counsel for the parties and upon going to the impugned judgments, this appeal is hereby admitted on following substantial question of law. Question number D. The parties have requested for an early hearing of this case. Let the records be called for from the concerned court. बताइए कब करेंगे? Thomas. When do you want? Second week of February. Record आने में थोड़ा time लगेगा. Did you pay special messenger cost? No, 100 रुपये भी नहीं देंगे. This is local matter?
And bar.
Yeah, 100 rupees for local messenger cost. You don't.
I'm told that scanned copies come, so there's a original actually, unless called for, original record would not.
Yes. Who is this case on 18th of February
18th of February.
in the supplementary contest? You have the records, I suppose.
Yes, sir.
ये जो है ना इसका एक फोटोकॉपी फाइल कर देंगे तो पता नहीं को दिख नहीं रहा जो देखिए कहीं तो होगा यार रिकॉर्ड में. Let this order be communicated to us. कुछ तो गड़बड़ है. अगर मान
ठीक
लीजिए
है.
एक बात बताइए.
कैलकुलेशन में क्लैरिटी नहीं है.
हाँ, कैलकुलेशन में क्लैरिटी नहीं है. And one more thing. Suppose this court finds that there is inconsistency. The matter in second appeal में कैसे decide?
In second appeal, but your lordship, the problem is even otherwise, although your lordship, the High Court is second appellate court, but then also it is an appellate court. So your lordship, order 41 rule 33 would still be applicable if your lordship finds that ultimately a proper order ought to have been passed. Then your lordship have all the power to correct whatever was required to be passed. Now, for that matter only, if the trial court or other orders are then they are remanded, then it would set aside, your lordship would have to set aside. And then that would only increase, only with regard to trivial matter. Otherwise, your lordship may remand.
Whatever evidences has come, we can just rectify.
Yes, yes. Finally, your lordship may adjudicate and
Now there is a great confusion as to whether there are two vendors.
yes, her name has come. Her name has come and
In what capacity
Yes.
we do not know whether she is the daughter.
Either that has been, means it has been partly allowed, Nasiran has been allowed, so that Zarina has not been allowed.
How is it possible when two persons are
no,
joining?
so my claim only with regard to Nasiran has been allowed.
That's right.
So I have not challenged. I am not
You,
challenged the
you
other
are,
part.
according to you, you are bought from Nasiran.
Nasiran.
Only.
And but Zarina's name has also come with regard to another sale. I'll have to verify.
We have to clarify
Yes,
that.
yes, yes. I do understand.
Item 10 second appeal.
Supplementary list में डालेंगे ना.
Item 10 second appeal 115 of 2020.
Yes.
Accepted, not put in.
Where rejected? ये तो 10,000 रुपये फाइन है. 1,000 रुपये फाइन ऑलरेडी लग चुका है. Now the adjournment without advance notice of adjournment is not permissible.
Second half.
सेकेंड हाफ में भी हमारे दो मैटर्स फिक्स्ड है, उसके बाद ही मैटर देंगे. आज एक सेकेंड, आज कोई ऑर्डर्स भी है केसेस?
Order check. Seven. Item 11 second appeal 190 of 2020.
If your lordship would take it after 12:30,
Okay, come at me.
because I have to verify something.
Item 12 second appeal 151 of 2022.
Appellant, you are there? Reversal order. The suit was dismissed. Appeal dismissed. The suit was dismissed. The suit is dismissed on contest.
I was the defendant in that suit.
Yes.
I was the defendant. Then appeal was
Allowed. Appeal was allowed.
Appeal.
Yes. Yes. Agree or yes?
Lordship, the case of the appellant is the lordship. One sale deed was executed. Sale deed was executed by plaintiff on 3/2/1997.
Just a minute. The plaintiff was claiming the property by virtue of sale.
Sale deed.
Dated
Dated 3/2/1997.
3/2/1997. Sale.
Suit was filed for cancellation of sale deed number 256. Dated 3/2/1997. Number 2, declaring the sale deed number such and such is illegal, bogus, and inoperative under law.
That's right. What were the issues framed?
Issues were framed
By the trial court? You claim that it is without valuable consideration.
Lordship, the plaintiff claimed that
Yes, the
this
plaintiff claimed that it is without valuable
valuable
consideration.
consideration. That has been decided by the
Trial court.
trial.
Trial court said what? Let us have a look at it.
Lordship.
There is a finding that it was for consideration. There is a finding that it was for consideration. Right?
I find that after execution of salvage, property was given to the defendant. Apart from this, I also find that Exhibit B, B1, C all corroborated the pleading of the defendant that before selling the land, original plaintiff handed over the salvage related to the suit property to Jharkhand.
What has been done by the appellate court?
Appellate court has framed another issue, Your Lordship.
What is
Apart
that
from
issue?
this.
What is that point of determination by the appellate court?
It is at page 9 of the judgment, Your Lordship.
Yes.
7.6. Whether the possession of the plaintiff become adverse to the defendant, despite the fact that the defendant have disregard the sale deed in favor and whether the adverse possession has made the defendant here in remedy less to ask the plaintiff from the suit property.
Was it a case of adverse possession?
No, Your Lordship.
that was not the case of adverse possession. Defendant was contesting the suit on the basis of title. On the basis of title. And the defendant did not raise any plea of adverse possession.
No.
Let us see the
Plaintiff did not raise any plea of adverse possession.
okay. This issue was decided at the instance of the plaintiff.
Plaintiff.
Okay. For the learned counsel appearing on behalf of the appellant. The learned counsel for the appellant has submitted that the plaintiff was claiming title over the suit land. The suit was filed seeking a declaration and seeking cancellation of SAIL number 256 dated 3/2/1997 being illegal, bogus, inoperative, and also permanent injunction restraining the defendant from claiming herself to be the owner of the suit property, and also for confirmation of the possession if the plaintiff was found dispossessed. And if the plaintiff was found dispossessed, then for recovery of possession and other relief. The learned counsel for the appellant has submitted that the suit was dismissed by holding that the sale deed was duly executed and was for consideration, and the plaintiff could not prove fraud, misrepresentation, or undue influence. She submits that the appellate court decided the appeal filed by the plaintiff by framing an additional issue of adverse possession the additional issue of adverse possession at paragraph 7.6 of the appellate court judgment, and was of the view that no evidence is required to be taken. She submits that it was never the plaintiff never rested their claim on the plea of adverse possession. Rather, they were seeking cancellation of sale deed. This, after hearing the learned counsel for the appellant, this appeal is admitted for final hearing on the following substantial question of law. Whether the learned lower appellate court was justified in framing additional issue of adverse possession in an appeal filed by the plaintiff, although the plaintiff never, in an appeal filed by the plaintiff, although it was never although the plaintiff never pleaded any case of adverse possession in the plaintiff. B. Whether the learned lower appellate court, after framing additional issue of adverse possession, could decide the case without taking further evidence in connection with the additional issue of adverse possession. Issue notice to the respondents for which requisite under ordinary process be filed by the applicant within a period of 1 week, that the records be called for from the concerned court, post this case on 27th February in the supplementary process. Yes.
Item 13, second appeal 161 of 2022.
Say create 2 weeks.
Case what?
2 weeks.
For what? इसमें आपका एडवांस नोटिस है, क्यों आपको 2 वीक्स चाहिए भाई?
एक दो मैटर आज करना है, इसको पढ़ा होता है। हियरिंग का मैटर
Judgment of confirmation. An advance notice seeking adjournment has been filed in this case. Also, for the appellant has submitted that the matter will be placed after 2 weeks, and on the next date you shall not see any adjournment. Correct? Post this case on 13th of February in the supplementary process. It is made clear that no further adjournment will be granted. आपका undertaking भी. So,
Item 14, second appeal 173 of 2022.
yes, appellant. Yes, sir.
there is a concurrent finding.
You are the plaintiff or the
I'm
defendant?
defendant. I'm defendant.
Defendant. What was the suit for?
So for the declaration of right title interest, they have not claimed for possession.
They were already in possession.
We are already in possession. Appellate my lordship.
Is there any finding that you are in possession?
This issue
We are
was
not
never
bothered
been
about
framed.
We are not bothered about it. We are only concerned with the findings.
The first appellate court, my lordship, have not framed this issue. However,
Not
my
framed?
in the revisional survey, my lordship, we have exhibited those documents. In revisional survey, my lordship, we are found in possession. My lordship, the issue of friendship is regarded that to prove the possession, not the title, my lordship. However, in the revisional survey in Khatian, we have showed in possession. We have also exhibited those documents also, but this issue was never got framed. And my lordship, without seeking recovery of possession, my lordship, and right title of interest is barred under section 34 of civil specific.
If anybody is disturbing, they are also seeking confirmation of possession.
No, my lordship, no, nothing sort of that. In plaint, my lordship, I have a copy of the plaint also. Supreme Court, my lordship, latest judgment in 2024 says that without seeking recovery of possession, right title of interest cannot be cleared.
Show me that.
Just print out.
What was the cause of action? What was the cause of action to file
Cause
this?
of action, my lordship, they have stated in the plaint that they have threat that the appellate may, this appellate may dispossess them. Issue of possession come into play only when both the parties dispute each other's possession.
Yes.
And they are here both
The
the
plaintiff also filed a case of miscellaneous case in the court of additional collector for stay of such manipulation.
But possession is not disputed.
Maybe, but they had a cause of action because Jamabandi was created.
I am not disputing the cause of action. I am disputing that for seeking a relief for right title interest, my lordship, the plaintiff must show that he is in possession, my lordship, and without seeking recovery of possession, the right title interest cannot be decided.
Even if he is in possession, he has to claim recovery of the
No, my
possession.
lordship. If he is not in possession, then he has to claim.
If somebody has sold my property, and I have doubt regarding that whether he can sell my property, I will not seek a declaration of my right title and interest.
Yes, my lordship, but we have to show that I am already in possession, so I am already seeking right title interest.
Yes.
They must show, my lordship. Because, my lordship, in revisional survey, my lordship, those are the exhibits.
No,
we
they
have
must show
shown in
means
the-
they pleaded that they are in possession.
Yes, they in plain they have pleaded that we are in possession.
That's
In
it.
written statement, we have denied that we
That's
are.
right. So there could be a dispute regarding
Yes,
possession.
but that issue has never been decided in this case. Who is in possession? Because if both parties are contesting their possession, my lordship, then it becomes vital and critical, my lordship, to decide who is in possession right now. And without that issue, my lordship, this issue has never been framed, my lordship, by the trial court and also by one determination of point was framed by the
Let us see the
issues, my lordship.
issues framed by the learned
Yes.
trial court.
Is that page number?
Who claimed the plea of? Who raised the plea of adverse possession?
No, nobody is claiming that was possession. We are stating that we are in possession. Our name appeared in the original survey khata Khatyans exhibit. We have also marked, and they are claiming that they are already in possession. So both are claiming that we are in possession. When both the parties are claiming market, that is why I am saying that both the parties are claiming possession market, then this issue is vital market deciding who's in possession. Because without claiming market, without deciding issue, market cannot be moved further, my lordship. Page 20 में issue frame trial करने में इसका trial court.
Who is Subedar Mian? Who is Subedar Mian? You are the defendant
Yes, we are all through defendant.
and were also the appellants.
The appellants were here. We are also appellants. Concurrent finding हुआ है. Position को discuss नहीं किया. Appellant court has discussed that they have already pleaded in plain that they are in position. Then there is no.
Who is Subedar Mian?
I just.
Perhaps your ancestors.
Yes, we are defendant by the
Sir Sirajuddin Ansari and Sohrab Ansari were sons of Subedar Mian.
ancestor of defendants.
It is the judgment.
While Manoj had we are going to take print out.
हम क्या करें?
In 2024, Manoj held that the suit for declaration of title without seeking
What
recovery.
is this? What are you doing?
I will. My password is
क्यों शुरू किए? बहस करना जब जजमेंट नहीं था हाथ में तो?
I thought my lordship she had.
What means what?
एक केस लेकर
फोन लेके एक लाइन पढ़ते हैं।
हम पूरा
कोर्ट ऐसे चलेगा आपका फोन से?
नहीं, I apologize. My fault. I will personally go and take it.
लेके आइए चलो।
Item 15, second appeal 177 of 2022.
My lordship, I'm seeking 2 weeks adjournment.
आपको लास्ट चांस हो चुका है तुम?
My lordship, Praveen Khori has to assist my lordship in this matter and
Why last chance was already given to you by way of last indulgence?
it's one opportunity to assist my lordship in a better.
What
and
better?
That is, for that he is seeking adjournment and
Adjournment
Personal.
ऐसे नहीं होता है. When there is a judicial order by way of last indulgence, I will not adjourn it. It is not your right. Seeking adjournment is not your right.
so that is what I am praying for, my lordship. I'm not asking as a matter of right.
So there is already a judicial order by way of last indulgence.
Yesterday only we have moved and adjournment.
ये जो mentions की बात है ना, last order के साथ ही लगाया है. Ask the councils to give the mentions slip along with the last order. और जिसमें last chance हो चुका है उनका mention slip accept करने का कोई काम नहीं. We will not accept mention slips like this.
In future we will be attending.
देखिए second appeal number 177 of 2020. नाम बताइए. Mr.
Sharabil Ahmed.
Shirabi Ahmed submits that he has been engaged in this case only yesterday.
Instructed by Mr. Praveen Khori.
Where is he?
Lordship, he is
Slip file करके गायब.
My lordship, he is for some personal difficulty. He is not present today.
Mr. Shirabi Ahmed, but you said that you have been recently engaged, right? Sentence में backtrack मत किया करो. जो बोलते हैं वही लिखा करो. Mr. Shirabi Ahmed
Ahmed.
submits that advance notice seeking adjournment for 2 weeks has been circulated. However, there is a judicial order that prayer for time was allowed by way of last chance on 27/8/2024. In view of the judicial order passed earlier, this court was not inclined to grant adjournment. However, counsel for the applicant has submitted that Mr. Praveen Khori who is advocate on record, is in personal difficulty. He has submitted that on the next date he shall not seek adjournment. No adjournment will be sought for in this case. Considering the aforesaid submissions, the matter is adjourned and is directed to be posted on 13th of February 2025 in the supplementary clause list by way of last indulgence. If the applicant is not ready to argue the case on the next date, appropriate order will be passed. Dismiss कर देंगे.
No minutes.
अगला डेट में डिसमिस करेंगे. बहस नहीं करिएगा. यही लिखा है नहीं that you are not ready to argue the case. I will dismiss it. ये लास्ट चांस होने के बाद इस तरह से नहीं होता. आइए फाइल करना पड़ेगा.
He will be here for assisting mediation.
Yes. आइए फाइल करना पड़ेगा सीटिंग एडजर्नमेंट.
Bye.
Item 16, second appeal 179 of 2022.
Yes.
Client is not in contact with us and we have no instructions from client.
SA number 179 of, so you don't want to press it. SA number 179 of 2022. MS नाम बताइए.
Alisha Lakra. Alisha Lakra.
Alisha Lakra, on instructions of Mr. Ayush Aditya, learned counsel and the advocate on record has submitted that the appellant is not in their contact and therefore she does not want to press this second appeal. Consequently, this second appeal is dismissed as not pressed. Communicate. साइन कराइए. एनरोलमेंट नंबर के साथ साइन करिए. रेस्टोर नहीं करेंगे इसको. देयर इज नो क्वेश्चन ऑफ रेस्टोरेशन.
Item 17, second appeal 190 of 2022.
Yes.
Your Lordship, I am paying for 1 week time.
Rejected. There is already on order of last chance.
Your Lordship, as a last indulgence,
10,000 rupees cost.
then the matter may be passed over for few cases of life.
Item 18, second appeal 199 of 2022.
Appellant. ₹10,000 कॉस्ट के साथ not today होगा because there is a judicial order of granting you last chance. ₹10,000 कॉस्ट दीजिए. 6 महीना का टाइम आपको. बिना कॉस्ट के केस रिटर्न नहीं होगा. there is a judicial order of last chance. कोई बात नहीं. कॉस्ट देने के लिए तो बाहर अंदर का कोई मतलब नहीं है. ऑनलाइन भी पेमेंट होगा. कब चाहिए आपको बताइए. 14 पे लिखिए. 14 के बाद 14 ऐसे नंबर 199 of 2022. MS मिस्टर शिव प्रसाद साहू शिव प्रसाद seeks adjournment by submitting that the arguing counsel is out of station. From the perusal of the records of this case, it appears that on 27/8/24 the matter was adjourned and therefore time was allowed by way of last chance. Today, the counsel for the counsel is seeking adjournment. No advance notice seeking adjournment has been circulated. However, considering the submissions, the matter is adjourned and is directed to be posted on 18th of February 2025 in the supplementary clause list, subject to payment of cost of ₹10,000 to be deposited in Advocate Clerks Association. इसका detail दे देंगे. The receipt of the deposit be filed before this court latest by 14th of February, failing which this appeal will stand dismissal without reference to it.
Item 19, second appeal 219 of 2022.
Appellant. Where is the appellant? Where is the appellant? Where is the respondent? You are there in this case?
Respondent.
What is the matter about it?
Matter with regard to the claim with regard to a tank, whether that is
There is already an order by way of last chance. Maybe that they are not interested. We'll dismiss this case. We'll pass it over. If they do not come, we'll dismiss it. We dismiss it. They are not interested.
the interest of justice
In the interest of justice, last chance was already granted.
was to be awarded and
आप डिक्टेट करेंगे order.
no, it's just
We remain in your limits.
municipality.
Okay, there is a judicial order by way of last chance. The matter was adjourned. Nobody is even seeking time. They are not here before this court. कि हम cost लगा के इसको adjourn कर दें. Who are you to say?
Just assisting, nothing more.
Mr. Rahul Gupta का केस है. He is already scheduled to come. उसी समय उनसे बहस करें.
Under the heading for hearing, item 20 wrongly listed, item 21, second appeal 240 of 2018.
Yes.
This is the plaintiff's second appeal against the judgment of affirmance lawsuit. The respondent is the defendant lawsuit. But you may kindly see the order number 5 lawsuit. Two substantial questions of law have been framed by this honorable court lawsuit.
LED कर सकता है.
As the defendant admitted that Winchester of the plaintiff was recorded tenant of the suit land, but the findings of the learned trial court that defendants have failed to establish the surrender of suit land by the ancestor of the plaintiff, namely Dayal Kumhar, and said findings of the learned trial court having not been challenged by any cross appeal or cross objection by the learned first appellate court having reached finality, whether the learned first appellate court committed perversity but not decreeing the suit of the plaintiff by allowing the appeal. Second, whether the learned first appellate court committed perversity overlooking the fact that though in Exhibit 3, which is certified copy of Khatiyan of Khata number 148, in column 3, it has been mentioned.
Please continue. Yeah, here. Again.
Plaintiff's appeal.
There are two substantial questions.
Two substantial.
Let us see the first one.
Yes.
When you read the first.
First substantial question, as the defendant admitted that the ancestors of the plaintiff was recorded tenant of the suit land, but finding of the learned trial court that the defendants had failed to establish surrender of the suit land by ancestor of the plaintiff, namely Dayal Kamhar, and the said finding of the learned trial court having not been challenged by any cross appeal or cross objection, reached finality, whether the learned first appellate court committed perversity by not decreeing the suit of the plaintiff by allowing the appeal. Now the facts are, admittedly, the suit land has been recorded as Kaimi and Batai Ses in the name of ancestor of the plaintiff.
Kaimi.
Kaimi.
Kaimi means what?
Kaimi is
Does it confer royalty rights?
Yes, possessory rights. And thereafter merits, it devolved upon the plaintiff. Case of the defendant is, they admit, yes, it was recorded as Kaimi in name of Dayal Kumar. But he had surrendered in 1939. He had
Whose
surrendered.
case was that? Defendant's
Defendant's case. He had surrendered in 1939 in favor of the landlord. And thereafter the landlord settled it in favor of the ancestor of the defendant. After going scrutinizing all
After surrender,
yes.
since considering the nature of question of law which has been framed, is there any filing by the learned trial?
Yes. That the defendants have failed to prove surrender.
If they have failed to prove the surrender, so ultimately the recorded tenant continued in possession,
yes.
And therefore the landlord did not have the right to sell it.
No. No. Thereafter, of course, there has been change after it is coming into effect of the Bihar Land Reforms Act.
What is the consequence?
The consequence is the superior landlord is the state, and the plaintiffs will hold it under the state.
Yes, that's it. So the descendants of recorded prayer had the right to sell the property because they became Rayat under the state.
Yes.
So transfers which were made by
no, there's no transfer. No transfer.
no, the fresh settlement made by the Zamindar does not affect the rights of the tenant.
Yes, no, that is what the learned trial court finds. That there is no, the defendants could not prove their story that it was surrendered by the recorded tenant.
And you are representing the
recorded
descendants of the recorded tenant. So, in absence of surrender, you say, after coming into force of Bihar Land Reforms Act, the recorded tenant had all right, title, interest, possession,
yes.
etc.
And they continue in possession.
Was there any rent receipt issued in favor of the landlord?
In favor of landlord?
The landlord or the subsequent settlement?
But I'll just take your
in my favor.
Rent receipt by whom?
I will just take your notice.
आप ऐसा साथ-साथ मत करिए, करने दीजिए. And in absence of that, any cross appeal to that?
Yes. There is no, the finding of the trial court that the defendants could not.
Is it a conclusive finding?
Yes, it is binding.
You sought for declaration of right, title, interest and possession.
Confirmation of possession, and in alternative merits, recovery of possession if found dispossessed.
अगर उस कब्जा दिलाया तथा किसी तरह का वो बंदोबस्ती कागजात है तो उसे शून्य एवं अकृत. In a case where it is one, let me just understand. In a case where the plaintiff is seeking right, title, interest and confirmation of possession on his own right, and he has got a doubt that the defendants may come up with some kind of deed, some kind of document, And instead of challenging that particular deed, they can simply seek a declaration that that is not binding.
Yes.
That declaration by itself is maintainable.
Yes, ma'am. It's maintainable.
So
I need not seek cancellation if I am not a party to that instrument or document. I need not seek cancellation.
And how the limitation would be governed under such circumstances?
But it's under, it will learn from the date of knowledge.
That some cloud. And suppose
Because I am
it
not
is-
party to that document. It
That's
has come
right.
to my notice for the first time. So it will come, the date of limitation will start from the date of knowledge. Of course, I have to prove that I had no prior knowledge.
That's right. But is it necessary for a plaintiff to get a declaration to that effect if he is already in possession?
But there are different views. Under section 34 of the Specific Relief Act, if I fail to challenge a document which may create some mischief regarding later on, it is it is required to be challenged. Because under section 34, if it is
If it's creating some cloud,
on my title.
Otherwise, also the defendant will have to prove his own title on in his own right.
Yes.
Just a passing reference to whatever. So many matters are coming, so I'm
Yes.
just wondering as to how to
Vast
handle
subject.
this kind of, because seeking a declaration that this sale deed is not binding is another thing from challenging the sale deed.
Yes.
These two are two different.
Because if I am not party to that sale deed, I need not seek cancellation. I can only by mere relief that it is not binding on me is sufficient. But if I am for example, if I say I was misled to execute this document,
That's it. Then
then
you are a
I
party
need
to it.
yes, I need.
Then you have to seek a declaration. It is avoidable document.
Yes.
Alright. Now let us see the issues framed.
Perfect. Internal page 5.
Yes.
क्या वादी का वाद अपने वर्तमान स्वरूप पूछते हैं सूट इज मेंटेनेबल, क्या वादी को वाद दायर करने उचित वाद उत्पन्न हुआ है, दैट इज वैलिड कॉज ऑफ एक्शन, क्या वादी का वाद परिसीमा अधिनियम एवं प्रतिकूल कब्जा से बाधित है, लिमिटेशन एंड एडवर्स पोजीशन, क्या वादी का वाद आवश्यक पक्षकार निर्दोष फॉर नॉन जॉइंडर ऑफ पार्टी, क्या वादी के पूर्वज दयाल कुमार है जिससे अटबट्टाईदार द्वारा सरेंडर भूतपूर्व जमींदार द्वारा किया गया तथा प्रतिवादी के पूर्वज को भूतपूर्व जमींदार द्वारा बंदोबस्त किया गया. दिस इज द मोस्ट रेलेवेंट. क्या वादी दयाल कुमार का पोता है, क्या दीपक कुमार दयाल कुमार का भाई था, क्या खतियान में उनके पूर्वज के नाम कायमी या अटबट्टाईदार
Which is the document in relation to possession?
Yes. The documents you have
Not the document, the issue. Issue number
Possession.
3. Is there any issue framed in connection with possession?
not specific, but issue number 3 has
3 would be maybe touching upon that. Where is the finding regarding possession?
Page 7.
Page?
Para 7. Page 7, para 7.
finding.
पूरा elaborate.
Finding जरा देखिए कहाँ पर है?
Finding
क्या
जो
है?
है जिसमें on basis of which the substantial question of law has been framed
Yes, let us see the finding.
is at starts from internal page 11. Can I read from the 4th line? from
Yes,
top?
yes, sure.
प्रतिवादी का दावा है कि विवादित संपत्ति को वादी के वंशज ने जब तत्कालीन जमींदार के पक्ष में इस्तीफा दिया तो दिनांक 10/4/1940 को तत्कालीन जमींदार ने साधन हुक्मनामा के माध्यम से विवादित संपत्ति प्रतिवादी को के पक्ष में बंदोबस्त कर दिया गया. तब से लेकर अब तक वो कब्जा में है और रसीद भी जमा कर रहे हैं. इसी आशय का कमोवेश समर्थन करते हुए प्रतिवादी की ओर से लाए गए सभी साक्ष्यों ने साक्ष्य दिया है. प्रतिवादी की ओर से दस्तावेज साक्ष्य के रूप में सादा हुक्मनामा दिनांक 10/4/1940 प्रदर्शन 1 चौकीदारी रसीद प्रदर्शन B से B/9 एवं ऋण रसीद प्रदर्शन C से C13 जमा किया गया। इस संबंध में सुसंगत ये हो जाता है कि प्रतिवादी अपने केस में ना तो सरेंडर सिद्ध किया है और ना ही ये सिद्ध किया कि यदि तत्कालीन जमींदार को तिलकधारी सिंह सहदेव ने विवादित संपत्ति को हुकुमनामा के माध्यम से दिनांक 10/4/40 को प्रतिवादी के पक्ष में बंदोबस्त कर दिया, तो जमींदारी जब राज्य सरकार में निहित किया गया तो उस समय इस आशय का घोषणा राज्य सरकार को दिया गया कि नहीं, क्योंकि इस तरह का कोई भी दस्तावेज साक्ष्य में अभिलेख के उपलब्ध नहीं है जिसके आधार पर हुकुमनामा के आधार पर बंदोबस्ती को कानूनी रूप से माना जाए। इसके अलावा जमींदारी अनुमूल्य के पश्चात प्रतिवादी का कहना है कि विवादित संपत्ति में कब्जा में लगातार में रहे, परंतु वादी की ओर से सूचना के अधिकार के तहत मांगे गए जवाब जिससे वादी की ओर से दाखिल प्रदर्शन 2 उपचार किया गया है, जिसमें अंचल कार्यालय से सूचना दिया गया कि पंजी 2 में प्रतिकार कॉलम में किसी का नाम दर्ज नहीं है। ये दर्शाता है कि C से C/13 रेंट रिसीट जो प्रतिवादी की ओर से जमा किया गया है संदेशास्पद है और इस तरह से प्रतिवादी का विवादित संपत्ति पर स्वामित्व का दावा हुकुमनामा प्रदर्शन 1 चौकीदारी रसीद प्रदर्शन B से B/9 और रेंट रसीद प्रदर्शन C से C/13 बिना अंचल कार्यालय में नाम दर्ज किए गए का तर्क भी सुसंगत नहीं होता है। अतः वर्तमान परिस्थिति में प्रेस इंग्लिश के स्थान और ऑपरेशन में आता है, इसलिए इस बात वर्तमान स्वरूप पोषणीय नहीं है।
There is a detailed discussion regarding this finding. So this
Just
question of law has to be answered in their favor. So on the face of it.
Lordship, can you permit to read it, Lordship?
पहले क्वेश्चन नंबर A क्या बोलना है? So the fact that there was no surrender, which was recorded by the learned trial court,
Yes.
became final.
Lordship, may can you see relief of the plaintiff, Lordship? I will answer the first substantial question of law, Lordship. May can you see the plaintiff, Lordship?
Yes.
A decree may be passed in favor of the plaintiff on the basis of R.S. Khatyan and possession of the plaintiff may be confirmed. He is claiming on the basis of Khatyan. What is the title of document of the plaintiff? The law is well settled that the record of right is not a document of title, Lordship. And the land was surrendered thereafter, Lordship, in the year
He is
1940.
claiming on the basis of the descendants of the recorded tenant.
But I am in possession since 1914. The exhibit B is the Chokidari rent receipt, Lordship. After vesting, Lordship, the Jamabandi was opened in
We
the
are on a different platform altogether. There is a finding recorded by the learned trial court that there was no surrender. You are claiming on the basis of surrender and hukumnama and rent receipt.
I am
and
claiming on the basis of Hukumnama.
Hukumnama. Right. Executed by the zamindar, and you took a specific plea that there was surrender by the recorded tenant. Isn't it?
Lordship, whether the land was surrendered or not, it is no question, Lordship. The question is that the landlord, Lordship, executed a hukumnama in my favor, Lordship, and thereafter the rent receipt.
The question is what we are seeing, the question of law.
Yes.
Yes.
Lordship,
The question of law is that in absence of this particular, you never challenge this finding.
Not necessary. Lordship, may can see judgment of the Honorable Supreme Court, Lordship, after amendment of CPC in the year 1976, Lordship, Order 41, Rule 20 is not a mandatory, Lordship. Judgment is 99.
नहीं, बात ये नहीं है, या तो ये बोलिए कि क्वेश्चन ऑफ लॉ गलत बना है।
हाँ, हम तो बोलेंगे कि
कहाँ बोले हैं अब तक?
नहीं,
अब तक तो शुरू भी नहीं किए। You are answering the question of law.
Lordship, may can see judgment, Lordship, the Honorable Supreme Court, Lordship.
You see, it is not your submission so far that this question of law has been wrongly framed.
Now I am saying, Lordship, he is arguing. Thereafter, Lordship, I am the just started argument, Lordship.
If the question of law has been wrongly framed, सबसे पहले तो उठ के respondent बोलेगा ना, this question of law does not arise for consideration in this case.
नहीं, तो start किए उसके बाद हम justice शुरू किए, अभी तो justice शुरू किए, कि cross appeal फाइल करना कोई जरूरी नहीं है। मैं kindly से judgment pass by the Honorable Supreme Court, Lordship. दोनों page 20, para 21, Lordship, मैं kindly से Para 21 Lordship. In our view, the opinion expressed by Honorable Court on behalf of the division bench in so and so view expressed by so and so Madhya Pradesh reflect correct position. After 1976 amendment, we hold that the respondent defendant in appeal can, without filing cross attack and adverse finding upon which a decree is a part has been passed against the respondent for the purpose of sustaining the decree to the extent the lower court has dismissed the suit against the defendant. So the filing of cross objection after 1976 amendment is purely optional, not mandatory. In other words, the law as stated in so and so case by Madras Full Bench and so and so case by this court merely clarified by 1976 amendment. There is no change in the law after the amendment. It is a purely optional lordship.
For the purpose of sustaining the decree to the extent the lower court has dismissed the suit against the defendant.
Some of the observations against the lordship by the learned trial court. Therefore, lordship, my submission is that for filing of cross objection is not mandatory.
So the provision of cross objection should have been deleted, isn't it?
Not deleted. It is an optional lordship.
You see, you read para 19.
Para 19 of the Honorable Supreme Court. The recommendation of Law Commission as reflected in the statement of the objection and reason for amendment they read as follows. Rule 22 gives two distinct rights to the
as it stood before 1976.
Yes. Rule 22 as it stood before 1976 gives two distinct rights to the respondent in the appeal. The first is right of upholding the decree of the court of the first instance or any of the grounds on which that court decided against him. And second right is that of taking any cross objection to the decree which the respondent might have been taken by way of appeal. In the first case, the respondent supports the decree, and in the second case, he attacks the decree. The language of the rule, however, requires some modifications because a person cannot support a decree on the ground of decided against him. What it means is that he may support the decree by asserting that the matter decided against him should have been decided in his favor. The rule is being amended to make it clear, and explanation is also being added. Rule 22 empowering the respondent to file cross objection is in respect to finding adverse to him, not withstanding the ultimate decision is wholly or partly in his favor. Observe in case of so and so that the amendment rule 22 of order 41 of the court has not brought any substantial change in the settled principle of law as accepted. So and clarified, page number 690, that it would be incorrect to hold that explanation now the inserted by Act 107 of 70 has made it obligatory to file a cross objection even when the respondent supposed the decree by stating the findings against him in the court below in respect of any issue ought to have been in his favor. In similar view are expressed by Justice after the amendment 1977, it was not obligatory to file cross objection against the adverse finding. The expression merely empowered the respondent to file cross objection. It is not mandatory.
So therefore, this question of law in view of this judgment
No.
is not mandatory.
Not mandatory.
You could have still argued the case with respect to the findings which were recorded by the learned trial court on the basis of which the decree was passed.
Lots.
That is all.
Lots.
But it's from the first appellate court judgment, it will transpire that they have not even argued on this issue. Findings which have been recorded against them, they have not addressed that.
Let us see the first appellate court.
Para 15 lots.
Whereas when
Points
we
for
come to
determination. Page 5, para 15. The learned first appellate.
the 3 points for consideration.
Para number 5.
15.
15. Page
Page
5.
five.
Yes.
Just yes. Can you read this?
Yes, whether the plaintiff has proved his case on basis of evidence, who have declaration of title and confirmation of possession and found not in possession, recovery of possession. Whether the suit of the plaintiff is maintainable in its present form, whether the judgment of learned lower court is sustainable in the eye of law or fit to confirm or required interference, alteration, modification. Now, after considering all these, practical lordship is a finding.
Just okay, what is the finding?
It starts from para 22.
Yes.
Coming to the oral evidence of the defendant, appears that P.W. type Sardar Kumar is appeared as a witness. And party was saying he has admitted defendant number 2 and own brother of defendant number 1. He has claimed that his title and possession of the suit land was recorded in the revision survey appear in the name of Dayal Kumar, who surrendered to ex-landlord Tilak Thakur Hari Singh on 5/139 and thereafter by unregistered Unnava dated 10/440 was settled to Chandra Kumar. The rent receipt was issued and they came in possession. After death of Chandra Kumar, the defendant are in possession. Invitation is granted in their favor. They are paying rent against government rent receipt, which is Exhibit C series. Though he has seen the Khatiyar but does not know what is written in the remarks column from the whole close examination of this witness, the plaintiff does not ask even a single question that is real sense. The plaintiff is in possession of the suit land rather. The last cross examination testimony suggested the plaintiff is in possession of the suit land, which has been denied by the witness. Well, another important aspect is that the learned trial court has disbelieved these rent receipts and chowkidari receipts. That is all. There is a finding to that. Coming to the document of the parties, skip paragraph. In this way, on appreciation of oral evidence produced by both the parties, it appears that though DW1 has not been able to describe the whole facts of the suit land the proper way, but as because the suit is filed by the plaintiff cannot take the benefit of the witness evidence weakness of the defendant, rather has to prove his all pleadings by his own independent evidence. From the whole oral evidence of the plaintiff, neither title nor even possession of the plaintiff has been proved. Coming to the documents of the parties, Exhibit 1 is admittedly order of SDO Ranchi regarding the suit land, which he has mentioned that as per report there is residential house of the second party, and therefore deciding the dispute by this court is not possible, therefore has dropped the proceeding with liberty to parties to approach civil court. Exhibit 2 is the notice which is in consonance of Exhibit 1 and is admitted fact but not touching core claim of the parties. Thus, Exhibit 1 and 2 are not document title and possession of the claim. To prove title possession and for grant of relief has sought in the plaintiff has filed Exhibit 3 as the prime document in his favor. On going through the document, it appears the Exhibit 1 to mention Schedule 6 MR Form 18 for Thakur settlement is printed as continuous Khatiyar, which is always fit to be read along with the original Khatiyar. In the absence of the original Khatiyar, continuous Khatiyar has no sanctity to be read into. More so when the important column number 17, which is remark column prescribed for noting current possession, The status of the land is complete blank. Further, Exhibit 3 does not contain date of its publication under Section 83 of the CLT Act. However, as because the defendants have admitted this fact, in the Khatiyar, name of Dayal Kumar is recorded. Exhibit 3, being a genuine document or not, is ignored for just decision of the case. On fact of admission of this document by the other side, I am inclined to go into the contents of the document in column number 3. Nature of settlement mentioned as Kayami, permanent. In column 4, it is mentioned that seeds and plants have been invested by the settlee, but the products of the land was to be divided half to the landlord. Nature of settlement is to be advertised along with cess. Learned counsel for the plaintiffs argued on the point that at the time there was custom to realize rent either in cash or kind. In term, and the term advertise, half vision or produce was the type of rent in kind. But I cannot be agreed with the argument of the learned counsel for the plaintiff.
Is there any finding on surrender?
No. That the surrender, there is a finding by the trial court. That,
But there is no finding by the appellate court so far as surrender is concerned. Because that was not in dispute.
No, that was, they had not raised the respondents, the defendant respondents, they did not raise any objection with regard to either when it's written or in course of argument with regard to the finding which has been recorded by the trial court that there is no surrender. They could not prove surrender.
But the entire claim of the defendants was based on surrender and subsequent surrender.
Yes. The appellate court mentions that though there are some typographical errors, but the judgment upholds the judgment in court.
So what is the reason which has been assigned by the learned appellate court?
The learned appellate court, when it says, kindly check, I was reading para 25, the Khatiyan, when the entries in Khatiyan have been disvalued. It makes out its own third case. Para 25 minutes, which I was reading. Can I continue?
Yes.
However, he has further argued that at the time of Zamindari system, there was only way of permanent settlement or direct cultivation. Therefore, according to me, whatever may be the condition of settlement, it was of permanent nature. When I examine this aspect of the matter, Exhibit 5 is the Banda Parcha, draft record of rights. Exhibit 5 filed by the plaintiff himself creates another hindrance in declaration of his title on basis of Exhibit 3 on the fact that Exhibit 5 is a non-standard document of settlement which has no legal sanctity. However, Khata number mentioned in black ink as 68 beneath the said number is an oblique number mentioned 161 in red ink. There is no authority or evidence to explain such entry in red ink. In oral evidence, the plaintiff has not explained this fact. However, in the remarks column, the illegal possession of Koka Kumar is mentioned of the said village, whose heirs are admittedly not made party to the suit. Khata number mentioned as 147 in CS cadastral Khata is said to be 148. If this fact is taken into consideration, I fail to understand what, when entry of Dayal Kumar is already mentioned in survey record of right, what was the occasion and need to issue unrecognized document of title. Therefore, Exhibit 5 is all difficult to be accepted as genuine document, to be treated as document either of proof of title or possession. Therefore, find that on factual aspect, oral and documentary evidence, the plaintiff has not been able to prove either his title possession even in accordance of probability. Even if I ignore Exhibit 5 minutes, that is draft record of rights. That is not finally published. But Exhibit 3 is there, it is an admitted document. Name of my ancestor is there. Case of the defendant is that my ancestor had surrendered in 1939. There is a finding to that effect that there is no evidence of surrender.
And even the appellate court does not record anything with regard to evidence of surrender.
Yes.
Even if his case is taken into consideration, this judgment is taken into consideration, your case at best would be that they never challenged that finding at any stage. And therefore there was no occasion for the appellate court to record any finding to that effect, that there was no surrender. And once there is no surrender, then the entire right of the defendant.
Testing
False.
false.
What is the second question of law?
Whether the Learned First Appellate Court committed perversity in overlooking the fact that though Exhibit 3, which is certified copy of Khatiyar, Khata number 148 in column number 3, it has been mentioned that the nature of settlement is Kayani. Hence, there is no way there could have been any surrender by the ancestors of the plaintiff, namely Dayal. That is what is dealt with in para 25.
He has disputed this particular entry, although it was an admitted fact that it was recorded
Yes.
in his name. It was a case, specific case of the defendant that it was followed by surrender and then resettlement. ये तो बात सही है ना?
हाँ.
ये तो this is absolutely beyond a third case being made by the appellate court.
No, my submission would be before this unknown court is that a suit for declaration of title and confirmation of possession onus upon the plaintiff to prove his title, and the plaintiff having failed to prove his title, Lordship.
No, just a moment. The plaintiff is admittedly the descendants of the recorded tenant. They are
Yes.
claiming through the recorded tenant.
Yes, yes.
It is not in dispute as to who was the recorded tenant. Was
Yes.
it in dispute?
Yes. No.
क्या नाम है recorded tenant का?
Dayal
Dayal Kumar.
Dayal Kumar. Right? Okay. Now defendant made out a case that there was a settlement, there was a surrender by Dayal Kumar, and therefore there was a settlement followed by a settlement. And defendants came in possession of the property. The defendants failed to prove the surrender by, this has been recorded by the learned trial court. The appellate court does not record any finding because this finding was not under challenge before the appellate court. Correct? And otherwise also no arguments were advanced on this, that this finding is incorrect, even if it is not specifically challenged before the learned appellate. Then consequently, where was the occasion for the learned appellate court to question the entry in the record of right, which was an admitted fact between the parties? How could he come to this kind of a finding that has not been Dayal Kumar? I fail to understand that when the entry of Dayal Kumar was already mentioned in the survey record of right, what was the occasion and need to issue unrecognized document of right to verify this?
Lordship, this objection is only relating to Banda Parcha, Lordship.
Whatever it is.
Relating to Banda Parcha, Lordship. Therefore, this observation has come, Lordship, according to us.
So otherwise also this, according to you, this observation in connection with Banda Parcha has no relevance.
Yes, Banda Parcha is also not a document of title, Lordship.
Not a document
Not a
of
document
title.
of
That
title.
too not final.
Not final publication.
Not final publication.
So what do you say? आप तो इनके फेवर में डिसाइड कर देंगे. आप बताइए आपको क्या बोलना. आपका क्या चीज लिख के डिसाइड करें?
Lordship,
आपका क्या आर्गुमेंट लिख के डिसाइड करें? The prima facie his case appears to be fit to be allowed. All these questions of law are fit to be answered in his favor.
yes. Lordship, may kindly see the judgment.
Now we have seen the concludes.
Lordship,
This
may kindly-
judgment we have seen, correct? This judgment we have seen that it was absolutely open. But merely because it was open, but that was to be raised. There is no raise. You have not raised it before the appellate court. Also that this finding is standing, is staring against me, and therefore what is the consequence of this finding, or this finding is incorrect. There is no such argument, and therefore the appellate court has not recorded any finding on that.
That may be remanded to learned appellate court, Lordship. Maybe
As a
if it is not recorded, Lordship, may be remanded to Lordship.
No, there is no
Learned-
since it was
learned-
not under challenge, therefore there is nothing, there is no such recording.
But question
Maybe
is,
that you did not raise any cross objection, fair enough. You don't need to raise any cross objection, that is also, let us take it for granted. But at least you have to raise it somewhere.
This is the first option. So far, the first substantial question. Second is that I am putting a question to myself: what is the documentary evidence of the plaintiff relating to title lottery?
The documentary evidence of the plaintiff is the case of the respective parties. The plaintiff claimed to be the descendants of the recorded tenant. Correct?
But law is well settled, Lord say. He is claiming the title on the basis of record of right. He is claiming the title on the basis of record of right. This honorable court may consider, Lord say, whether a record of right is a document of title or not.
It was your case
Lord,
that
in this case, Lord, I am not the plaintiff. The appellant is a plaintiff. He has to prove his own title, Lord. He cannot take advantage of the witness of the defendant, Lord. He has to prove his own case, Lord. Lord, make any judgment, Lord. I want to show before this honorable court, Lord.
There can be, let me complete.
हमको complete
Let me just explain.
हमको repeat करेंगे फिर आप करिए. 2 ways. 14 2 ways. Para 12 and 15 lots.
yes.
It is title law that in a suit for declaration of title, burden always lies on the plaintiff to make up and establish a clear case for granting such declaration and the weakness. If any of the case set up by the defendant would not be ground to grant a relief to the plaintiff. And para 15 lots, the legal position therefore is a clear that plaintiff may suit for declaration of title and possession could succeed only on the strength of his own title that could not be done only by adducing sufficient evidence to discharge the onus on it, irrespective of question whether the defendant has proved their case or not. We are view that even if title set up by the defendant is found against him, in absence of establishment of plaintiff's title, the plaintiff must be non-suited, Lordship. In this case, Lordship, he is claiming on the basis of record of right. He is claiming the title on the basis of record of right, Lordship. And
What was his case? What was his case?
His case is only record of right.
Not record of right. His case is that he was the recorded tenant.
No. He was recorded of tenant, and in the year 1939 the land was surrendered.
Surrender has not been.
But in the year 1940, Lordship, the Hukumnama was issued in my favor, in favor of the defendant, Lordship. Thereafter, Lordship, I am in possession of the land. May kindly see written statement, Lordship, for a moment, Lordship. Written statement. Para 15 lots. May I please know? Para 15 of the written statement.
Is it from the improved judgment?
Let's make at least 4 amendments, Lord. Para 15 of the. Thereafter, Lord, I will place the judgment of the learned first appeal court, Lord. And also evidence of the plaintiff, Lord, relating to possession, Lord.
Let us see the case of the plaintiff and then we will see on this.
Lord. May I please para 15, Lord?
First, the case of the plaintiff.
The plaintiff case is only on the record of right, Lord.
Let us see. You read it.
From the judgment of learned first appeal to the learned
but-
trial court.
Yes, certainly. You
Yes.
read the plaint. You want to read the written statement. I
Yes.
want to read the plaint with the written
Yes.
statement. You just read it.
Para 7, Lord.
Para 2.
Para 2. Para 2 of the plaint.
Yes.
Plaint.
Lordship is referring to plaint or the judge?
The plaint.
That the parties are by caste Kumhar governed by their Hindu law in the matter of inheritance and succession. The record of right bearing Khata number 148 in the name of Dayal Kumar who died living behind only son गणेश कुमार. यहाँ भी गलत है. इनका एविडेंस में आया है कि दयाल कुमार का 2 बेटा है. एक गणेश कुमार.
वो सब इशू नहीं है. अब आप पढ़िए. आप बोलते हैं कि इनका केस ही नहीं था इसलिए हमें
मेरा सबमिशन ही इनका केस ही नहीं है टाइटल का. Also died leaving behind only one son, Hari Kumar. The plaintiff in this case, even though the Ganesh Kumar had one brother, Vidya Kumar, who died leaving behind only his widow Sonamani, and one daughter. The daughter already got married and living in her father-in-law house, but her mother, wife of Vidya Kumhar, is still residing in the care and guardianship of the plaintiff. She is not made the independent parties in this case. The denial is given under in the schedule of the plaintiff. The land in dispute situated in village 2, Oromhanji, Irva district, Ranchi, bearing Khatan 148, plot number 161, area 39 decimal, which is mentioned in schedule G of the plaintiff. That very short, while this defendants.
The record of right recorded it as ad batai mein shesh. So there was no question of any payment of rent. As per the plaint, ad batai mein shesh matlab, you see,
Produce the half.
Produce the half.
हाँ.
That is the rent. Right? इसके लिए कोई rent receipt का issue होगा नहीं. Right? This is the record of right.
Record of right.
इसका कोई rent receipt issue नहीं होगा. ad batai. Correct? And then they also say that
नहीं कहाँ record of right में कहाँ लिखा हुआ है?
record of right में ad batai में लिखा हुआ तो है. You just have a look at it. As per the plaint itself,
column number 3 में कायमी लिखा हुआ है.
in RS record of right recorded as Kayami within bracket ad batai में शेष. लिखा हुआ है.
नहीं ऐसा कहाँ लिखा हुआ कि रेंट इशू नहीं कर सकता है?
ad batai में शेष में कैसे रेंट इशू होगा? आप भी अजीब बात करते हैं.
नहीं तो रेंट इशू तो मेरा इशू हुआ है.
नहीं हो. भाई इनका नहीं ना इशू होगा.
नहीं आफ्टर द वेस्टिंग हमारे नाम से तो चल रहा है ना जमाबंदी. और
कब से चल रहा है?
55 से हम एग्जिबिट सी दिखा रहे हैं. हम एग्जिबिट सी दिखा रहे हैं. अप टू डेट मेरा रेंट रिसीट्स है. हमारा अप टू डेट रेंट रिसीट्स है. एग्जिबिट देख लिया जाए लोग से. एग्जिबिट हम दिखाना चाह रहे हैं.
जमींदारी रेंट रिसीट है?
हाँ है.
कब का?
नहीं जमींदारी नहीं है. चौकीदारी रेंट रिसीट्स है.
चौकीदारी से क्या लेना देना?
चौकीदारी रेंट रिसीट आल्सो.
चौकीदारी रेंट रिसीट इज सेम एज जमींदारी रेंट रिसीट.
नहीं चौकीदारी रेंट रिसीट B/B9 है हमारा.
Is it the same as जमींदारी रेंट रिसीट?
नहीं वो तो अलग है.
वो अलग है ना?
वो अलग है.
तो फिर
but after the vesting lot
you see you say that it was surrendered and settled with you. Settlement is under by a registered deed.
And no hukumnama,
right?
Hukumnama
is not coupled with zamindari rent receipt in your case.
But after the vesting lot rent receipt issued and he admitted in his evidence that they are not possession of the land. I will show the evidence of the plaintiff lot say. Lot say can you see exhibit C to C by 13 lot say.
अब प्लेन पूरा नहीं पढ़ी.
अच्छा ठीक.
पैरा 4 पढ़ी.
ठीक.
Record of right is exhibit
3.
एडवर्टाइज में शेष लिखा हुआ रिकॉर्ड ऑफ राइट.
ठीक. पैरा 4 पढ़ रहे हैं. That it is better to mention if the RS recorder for right recorded is a Kayami at Badai Mrs. Therefore, question of alleged surrender does not arise when no rent is payable nor any constitutional money lying due. So, question of any alleged surrender does not arise. The learned SDO dropped the proceeding with the observation to let the matter decided in civil court is the suit before the owner. The defendant has or had no right title interest over the same, and defendant did not come into the possession for single day, but for the purpose of proper adjudication of this suit has been filed before this honorable court. Now I am coming to a written statement, Lord. Para 15. That from the facts stated above, it would be evident that defendant.
para 14.
Para 14.
13 people.
13. The then landlord subsequently orally settled the suit, land coupled with grant of rent receipts and delivery of possession followed by customary hukumnama dated 10/4/1942 to Chamra Kumhar, father of the defendant, who came into peaceful possession since the date of settlement and paid the rent to the ex-landlord before vesting. After vesting, he was recognized as the tenant and paid the
ये
rent.
नहीं है ना आपके पास जमींदारी रेंट?
नहीं, मेरा पास तो चौकीदारी रेंट है जो नहीं
आप प्रूव नहीं किए.
That the Chamra Kumhar, after taking settlement, constructed house over the suit land and resided there with his family members, including these documents, and remained in possession so long alive.
Just para 12 after
Para?
12. 11, 12 दोनों.
जी. The lands of Khata number 148, plot number 161, area 39 decimal, situated at village Hutta, police station, Romali, Thana, Solanpur district, have been recorded in divisional survey record of right finally on 3rd January 1931 in the name of Dayal Kumar, son of Chambu Kumar. The said Dayal Kumar was holding the land at Batai. Yes,
This is an admitted
yes,
fact.
yes, yes, I am admitting. The recorded tenant Dayal Kumar voluntarily surrendered entire 39 decimal of land, being RS plot number 161, Khata number 148, upstate village, to the then landlord on 5/12/1939, and the then landlord Thakur Tilak Dhari Singh came into peaceful possession of the land, and land he so surrendered became his Bakas land.
If this particular land became his Bakas land, then the rent receipt should have been issued first in the name of the zamindar. Isn't it?
Yes.
Is there any rent receipt issued by the zamindar, by the state in the name of the zamindar? No.
No, after vesting the rent receipt issued.
After vesting, the rent receipt is issued in your name.
Yes.
Not in the name of the zamindar.
Not the name, because I am in possession of the land. I am in possession.
And then you say that there was surrender.
Yes.
In the year 5/12/1939.
Yes.
Right?
Right.
उसके आगे बड़ी 30.
Para 30 lots. The deed and landlord subsequently orally settled the suit land, coupled with grant of rent receipts and delivery of possession, followed by customary hukumnama dated 10/4/1942 to Chamra Kumar, father of the defendant, who came into peaceful possession since the date of settlement and paid the rent to the ex-landlord before vesting and after.
Not true.
No, and after vesting, he was recognized as the tenant, paid the rent to the estate. That the Chamra Kumar, after taking settlement, constructed house over the suit land and resided there with his family members, including these defendants, and remained in possession so long alive. And after his death, the defendant, being the legal heirs, inherited the property and came into possession of the same, are still continuing in possession, are regularly paying the rent to the estate. That from the facts stated above, it would be evident that defendants are the absolute owner with respect to suit lands, along with the house standing thereon, have acquired the absolute indefeasible title thereto. Even if there is any defect in their title, same has been perfected by remaining in possession openly and adversely more than the stipulated period, that is, for about 70 years by the defendant. While their father was alive, he was in possession since 10/4/1940. The defendants have acquired the absolute and indivisible title, even if there is any defect in title, same has been perfected by remaining in possession openly and adversely to the knowledge of all the concerned, including the plaintiff and his predecessor.
Any issue on adverse possession was also?
Yes, yes.
What is the finding on that?
No,
there is no finding of the learned trial court, Lord. Neither by the
adverse possession was taken by them, but they did not address the court. That is what has been recorded.
नहीं, वो आपके बारे में लिखा हुआ है.
हम क्यों adverse possession
नहीं, आपके बारे में आया हुआ है.
Adverse possession आप claim करेंगे तो किसको address करेंगे?
Issue number 3 है.
Issue number आ रहा है उसके लिए.
Not pressed.
Findings.
नहीं, pressed आ रहा है.
Para page 12, internal page 12 of the trial.
Para 8 lots. वाद संख्या 3 और 4 का.
Point number 3.
3 and 4 is taken together.
Appellate court.
नहीं, trial court. Page internal page 12 lots. Para 8. वाद पद संख्या 3 और 4 के द्वारा न्यायालय को निर्धारित करना है कि क्या वादी का वाद परिसीमन अधिनियम प्रतिकूल कब्जा के सिद्धांत से बाधित है, तो न्यायालय को भी निर्धारित करना है कि क्या है वादी का वाद आवश्यक पक्षकार के दोष असहयोग से बाधित है. इस संबंध में उभय पक्ष के द्वारा अभिलेख पर कोई साक्ष्य प्रस्तुत
तो आप किसको एविडेंस देना था?
एविडेंस तो हमको देना था.
तो फिर नहीं ना दिए कोई
एविडेंस हमको देना था. एविडेंस तो
नहीं ना दिए, तो इसका एडवर्स पोजीशन का तो कहानी कोई नहीं.
नहीं, अब हम एविडेंस दिखाना चाह रहे हैं कि पोजीशन में है कि नहीं.
इससे क्या मतलब है?
नहीं, मतलब है
एडवर्स पोजीशन का तो कोई बात ही नहीं है. आप टाइटल का बात
नहीं, तो उसको तो फ्रेम करना चाहिए था लर्नेड फर्स्ट अपीलेट कोर्ट.
और आपको क्या करना चाहिए?
लॉर्डशिप में क्या सेक्शन 107 ऑफ द सीटीसी लॉर्डशिप पावर ऑफ द अपीलेट कोर्ट लॉर्डशिप
नहीं वो सब पावर ऑफ एपेलेट कोर्ट ने क्या आपके फेवर में एडवर्स पोजीशन का फाइंडिंग
नहीं, कोई फाइंडिंग नहीं दिया।
नहीं दिया
तो डिमांड का
नॉट
फीड,
रिक्वायर्ड
डिमांड का फीड केस है।
You never pressed this issue before the learned trial court. You did not need any evidence on that. Merely because you are paying rent. Merely because you are paying rent. Adverse possession आपके फेवर में डिसाइड हो जाएगा. There are so many elements of adverse possession. You raised it. Issue framed. No evidence laid on that. Not decided. Appellate court also not decided.
But he has to prove its title, its own
He
estate
has.
law.
You see, his title stands admitted by.
No,
unless you prove,
no.
unless
I am the admitted the only record of right, not admitted the title of the plaintiff
you
lordship.
say surrender. Where is the question of surrender?
Even if there is no surrender lordship, but the huknama was issued in favor of Chamra.
Advertise what?
Advertise the 50-50 lordship. 50-50.
That much is sufficient. Then entry
No
record of
sufficient
rights has
lordship.
got evidentiary
Then
value.
lordship I am permitted to.
अब क्या permitted
नहीं
हो?
है, judgment है. Whether the record of right is a document of title or not.
ठीक है, you have done your best. You have done your best. और कुछ नहीं.
नहीं अभी खत्म नहीं हुआ.
अच्छा.
अभी खत्म नहीं हुआ.
इनको रिकवरी ऑफ पोजीशन मिला है क्या?
नहीं, इसमें तो डिस्मिस हो गया.
हाँ.
रिकवरी तो नहीं मिली. पेज 11 नोट्स जो मार्क किए हैं. It is essential to mention here that record of right is not a document at all. Entry in such document do not prove the exclusive title of person so recorded. Once again, I am putting a question to myself: what is the document of title of the plaintiff? He is taking advantage of weakness of the defendant.
No.
Yes. Once again, Lordship.
It is recorded in the record of right.
But the record of right is not a document of title, Lordship.
Maybe not, but
No,
record of right
Lordship,
has got lot of evidence.
with due respect, Lordship, the record of right is not a document of title. I will show some judgment also, Lordship, before this honorable court, Lordship. Passed by this honorable court, Lordship. And so far as the range receipt is concerned, Lord, I am placing some before this one.
No rent receipts were issued in your favor.
No. Admitted, Lord. Para 13, Lord.
Yes.
When a matter of fact, this सब पढ़ रहे हैं, with your Lord's permission. Otherwise, I will.
ये कोई बात नहीं.
When, as a matter of fact, rent receipts are issued by the Karamchari and registered to is a document maintained with circle. These documents are a strong evidence of possession. And latest judgment of the Honorable Supreme Court, Lord. (2024) Lordship, the judgment of the Honorable Supreme Court. Sir. Para 8.2 Lordship. We find the argument convincing the several regions in their written statement before the trial court. The appellants did not specifically deny the plaintiff ownership of the suit property. Instead, they primarily relied on the plea of the adverse possession. Under Order 8 Rule 5 Code of Civil Procedure allegation of fact not denied especially are deemed to be admitted by asserting adverse position, the appellate has implicitly admitted the plaintiff's title. The defendants relied on the Jabandi entry in establish their ownership. The Jabandi for year 1969 to 1970 records the name of Sri Amin Lal as owner to the extent of half share. The revenue record are public documents maintained by government official in the regular course of duty and carry presumption of correctness under section 35 of the Indian Evidence Act 1872. While it is true that revenue entry do not by themselves confirm title, they are admissible as evidence of possession and can support a claim of ownership when corroborated by other evidence.
सर
नहीं, ये भी complete नहीं।
कंप्लीट नहीं मतलब एक ही पॉइंट पे एक जजमेंट काफी
हाँ काफी है, दूसरे पॉइंट पर आ रहे हैं। दूसरे
सर दिस जजमेंट इसमें वो भी तो है ना सब पैरा 1 भी है
हाँ
in the written statement in this case also they claimed adverse possession, you also claimed adverse possession,
yes,
so you do not dispute their title.
no, I am disputing the title of the plaintiff lordship. I am the possession of the land. Those judgment laws prove that I am the possession of the land.
Okay, fine. These two judgments
And
then
another
this one,
judgment lordship.
the
Entry in revenue record cannot be formed for declaration of title para 4. Sir. What's the mechanism para 4?
para 4.
G.
Yes.
In view of the rival contention, the question arises for consideration whether the plaintiff have been able to establish their title and courts below were justified in declaring the possession title. As has been stated earlier, once the piece of evidence on which the courts below relied upon to the degree of the plaintiff's suit is alleged order by assistant settlement officer directing the correction of the record of right. The order in question is not there on record, but the plaintiff relied upon the register where the correction appears to have been given effect to. The question therefore arises as to whether the entry in settlement paper recording somebody's name could create an extinguished title in favor of the person concerned. It is to be seen that the disputed originally issued recorded in the name of Raja Sahib of Keunothal, and thereafter the estate was recorded to be owner of the land in record of that prepared in the year 1949-50. In absence of very order of the assistant settlement officer directing the necessary correction to be made in favor of the plaintiff, it is not possible to visualize on what basis the aforesaid direction had been made. But at any rate, such an entry in revenue paper by no stage of imagination can form a basis of declaration of title in favor of the plaintiff. To our query as to whether there is any other document on the basis which the plaintiff can claim title over the disputed land, the learned counsel for the plaintiff respondent could not point out any other document apart from allegation correction made in the register pursuant to the order of the assistant settlement officer. In our considered opinion, the courts below committed serious errors of law in declaring the plaintiff title on the basis of a forced order of correction and consequential entry in revenue paper. In this circumstance, the appeal is allowed. In this case, also, lordship, the plaintiff lordship claiming the right on the basis of record of right, lordship. So far as the hukumnama is concerned, lordship. So far as hukumnama is concerned, lordship, the lord, sir. Para 16. Para 16 course. presumption of 30 years old documents, Lords. The Hukamnama Exhibit 8, which has inherently described as Exhibit 7, is substantial question of law formulated of this court, dated so and so. The said Hukamnama was brought on the record before the trial court on 2/5/1968, along with other documents as per the list of the documents by defendant number 8. Bagan Mahato from his custody. In the appellate stage, after death of Bagan Mahato, the plaintiff filed an application admitting the said Hukamnama into evidence. After hearing the parties on the petition dated 12/5/1986, its rejoinder dated 19/9/1986, the Relate Appellate Court below order for admitting the Hukamnama of Sambat so-and-so into evidence. Subject to depositing the impounded amount and report of Sarisdar was also called for in respect of thereof. The plaintiff has deposited so-and-so paisa impounding fee as per the report of the Sarisdar on 28/8/1987. Thereafter, defendant again filed a petition on 25/3/1988 for not admitting the said Hukamna into evidence, and rejoinder was also filed by the plaintiff on 11/4/1988. And by order dated 21/9/1988, the said Hukamna was marked as Exhibit 8 for plaintiff. It's clear the Hukamna has been brought on the record from the proper custody of the defendant number 8, Bagan Mahato, and said document is 30 years old. Since the requirement under section 90 of the Evidence Act having been fulfilled, the Relate Appellate Court has rightly admitted the said document into evidence, and there is no illegality in respect of it. Now let me make anything evidence, Lord. Whether the plaintiff are possession of land or not, Lord.
Possession has been declared in your favor. Is there any declaration of possession?
हाँ, हम आ रहे हैं.
है कि नहीं? पहले तो ये
नहीं,
बताइए.
थोड़ा सा हम देख लेते हैं इसमें और बता रहे हैं हुजूर कि इनका जो एडमिशन है वो हम दिखाना चाह रहे हैं. लॉर्ड से
आप जजमेंट से दिखाइए, इस तरह से नहीं होता सेकंड अपील में. जैसा एक तो इशू नहीं बना है पोजीशन.
नहीं बनाया हुआ
कहाँ बनाया हुआ पोजीशन?
लिखे
पोजीशन का कोई इशू नहीं बना है. सब्सटेंशियल क्वेश्चन ऑफ लॉ पोजीशन पे नहीं बना है.
नहीं बना है, मगर इनका कुछ एडमिशन है हम दिखाना चाह रहे हैं.
वो इस तरह से मत दिखाइए, जजमेंट से दिखाइए.
जजमेंट में तो नहीं आया.
नहीं आया है, बस क्या नहीं कर सकते. अगर इनके क्रॉस एग्जामिनेशन में तो ये है कि when the defendant came to take possession, they went to the circle officer and then they came to know that they are claiming possession and consequently the suit was filed.
ठीक, हम दिखाना चाह रहे हैं PW1 का लॉस.
ऐसे नहीं होता है, पोजीशन का कोई इशू नहीं है. पर इस तरह से
नहीं तो एडमिट कर रहे हैं हम, पोजीशन में नहीं है. एडमिट कर
दिखाइए, जजमेंट से दिखाइए. ऐसे हम एक एविडेंस और एक सेंटेंस पढ़ के केस को
नहीं तो इनका ही एडमिशन है.
एडमिशन जजमेंट में दिखाइए.
एडमिशन में लॉर्डशिप फर्स्ट अपीलेट कोर्ट में नहीं आया है, तो which is error of which is required to be reconsidered by the learned first appellate court, lordship. According to section 96, lordship, the first appellate court is duty to see all the evidence, law and fact also.
सेकंड अपील में क्या देखना है? क्वेश्चन ऑफ लॉ.
Only substantive question of law, lordship.
हम वही बस वही देखना है. इसके beyond नहीं देखना. That's all. You also say anything in this?
Yes.
What do you have to say regarding the entry in record of rights?
So entry in record of rights, if there is no other any rival, because I can claim immovable property either by way of entry in record of rights or by way of a sale deed, instrument like sale deed, gift deed. If there is no other
Instrument.
no other instrument, entry in record of rights does confer title. Perhaps the judgment my friend is relying, there were other instruments which were with the rival instruments.
So at best you can say that there was no instrument. You were simply handed over the property on Akbar time.
On Akbar time basis?
Because you never claimed also that there was any instrument.
No,
of
I never
handing
claimed.
it over.
Because I claim on basis of entry in record of rights in favor of my ancestor. Now with regard to possession, my lords may kindly see.
No, this part is not complete. He's hyping so much on this. So do you have any authority on this?
Yes, I have a quick. The presumption with regard to entry in record of right, which there is one judgment. It's para 28.
Yes. So your contention at best would be that this entry, whatever was the entry in the record of right, was not in dispute.
Not in dispute. Yes.
They never challenged that it is a wrong entry.
Correct.
At best.
And they say that it was surrendered by.
Yes, that was their specific case.
That I surrendered, and thereafter it was resettled by the landlord in their favor. Learned court below Millet has disbelieved that. And again, as I pointed out, they did not raise this objection in the first appellate stage. Secondly, Millet, Exhibit 4 is very important. That is information given by the circle office before filing of the suit on 24/9/2009.
Exhibit 4, what is the relevance of that? And
Yes.
where is the discussion?
There is a discussion at internal page 11. If I come to
On the appellate court?
trial.
Yes.
If I read towards from the middle towards इसके अलावा जमींदारी
उन्मूलन के पश्चात
हाँ उन्मूलन के पश्चात प्रतिवादी का कहना है कि विवादित संपत्ति का कब्जा में लगातार बने रहे, परंतु वादी की ओर से सूचना के अधिकार के तहत मांगे गए जवाब जिससे कि वादी की ओर से दाखिल प्रदर्शन 2 एवं 4 अंकित किया गया है, जिसमें अंचल अधिकारी से ये सूचना दिया गया कि पंजी 2 में प्राधिकार कॉलम में किसी का नाम दर्ज नहीं है। ये दर्शाता है कि प्रदर्शन C से C13 रेंट रिसीट जो कि प्रतिवादी की ओर से जमा किया गया संदेहास्पद है, और इस तरह प्रतिवादी का विवादित संपत्ति पर स्वामित्व का दावा प्रदर्शन 1 हुक्मनामा प्रदर्शन 1 चौकीदारी रसीद प्रदर्शन B से B9 और रेंट रसीद प्रदर्शन C से C13 बिना अंचल कार्यालय में नाम दर्ज किए गए का तर्क भी सुसंगत प्रतीत नहीं होता है।
This is on the basis of right to information.
Yes, under right to information, the circle office informed that there is no entry with respect to the suit land in registered 2. So therefore, there is a finding.
The record of right would be different from registered.
Registered
These
2
are
is
two different documents.
these are two different. So registered 2 में इनका entry नहीं है, तो रसीद भी संदेहास्पद है. And this finding is also not assailed in appeal.
That is all.
Yes.
Second appeal number 240 of 2018. Heard the learned counsel appearing on behalf of the parties. This appeal has been filed against the judgment dated 8/5/2018, decree signed on 21/5/2018, passed by the Additional Judicial Commissioner Roman 2 at Ranchi in civil within bracket title bracket close appeal number 46 of 2016 /CNR-J8R number 1-006816 of 2016, whereby the appeal preferred by the plaintiffs/appellants has been dismissed. and the judgment dated 29/11/2016, passed by Learned Munsif, Civil Court Ranchi, in title suit number 1 of 2010, has been affirmed. It's a judgment of affirmation.
Yes, sir.
Has been affirmed. This appeal has been heard on following has been admitted for hearing on following substantial question. The learned counsel for the appellant has submitted that the appellant was the plaintiff before the court and claimed that in the record of rights, the property was shown as advertised and settlement was Kayami within bracket permanent in favor of Dayal Kumhar. And the plaintiffs were the descendants of Dayal Kumhar. He has further submitted that the plaintiffs were in peaceful possession of the suit land without any interference. However, some cloud was created when a proceeding under section 144 of CRPC was instituted and the defendants claimed right title and possession over the suit land. He submits that the plaintiffs, the record of rights was prepared in the name of Dayal Kumhar in the year 1935. The learned counsel submits that consequently the plaintiffs filed a suit for confirmation of their title on the basis of RS Khatiyan and possession for a suit seeking that a decree may be passed in favor of the plaintiff on the basis of RS Khatiyan and possession of the plaintiff may be confirmed, and if dispossessed, possession may be delivered through the process of court. It was also prayed that if any surrender deed or subsequent settlement was made, the same may be declared null and void, and the same may not bind the plaintiff. The learned counsel has further submitted that the defendants appeared in the suit and claimed that Dayal Kumhar and did not dispute that the property was recorded in the name of Dayal Kumhar in the finally published record of rights on 3/1/1995 as Advertidar, but pleaded that Dayal Kumhar voluntarily surrendered the suit land on 5/2/1939 to deed and landlord Thakur Tilakdari Singh, who came in physical possession of the suit land, and it became his vakast land, and thereafter the landlord orally settled the suit land coupled with grant of rent receipt and delivery of possession, followed by customary hukumnama dated 10/4/1990 to Chamar Kubhar, the father of the defendants, and he was put in physical possession of the property, and since then they remained in physical possession of the property. The learned counsel submits that the defendants had also placed reliance on certain rent receipts and also chowkidari receipts. He submits that at the stage of trial, a detailed finding was recorded after discussing the materials on record that the defendants could not prove the surrender of the suit land in favor of the then landlord, which was claimed to have been surrendered on 5/12/1939. The learned counsel submits that the learned trial court, however, ultimately dismissed the suit. He has also submitted that the defendants also raised a plea of adverse possession, but the learned trial court framed an issue also, but learned trial court recorded that no evidence was produced in connection with the plea of adverse possession. So far as the learned counsel thereafter submits that thereafter the plaintiffs filed a plea, and at the appellate stage neither any cross objection was raised from the side of the defendants who were the respondents at appeal with regard to the finding that they had failed to prove the surrender. He also submits that no argument was also advanced in connection with the said finding on behalf of the defendants before the appellate court, first appellate court. However, in spite of the fact that the finding in connection with surrender having not been proved by the defendant attained finality, but still the appellate court recorded that the plaintiff has not been able to prove his title or possession even on preponderance of probability. ये finding है ना? Finding है para number 25. Appellate.
Yes, this is with regard to the entries in record of rights.
Yes.
And draft record of rights.
Yes.
What the question?
The learned counsel has submitted that this finding was recorded primarily on the basis of draft record of rights, that is Exhibit 5, which had not attained finality. He has submitted that such finding was not in accordance with law. the Learned Counsel submits that on the face of the finding that the defendants could not prove the surrender, the appellate court ought to have decreed the suit in favor of the plaintiff. Correct? The Learned Counsel has also submitted that so far as the substantial question number 2 is concerned, the entry in record of right, that is Exhibit 3, which remained undisputed which remained undisputed was sufficient to prove the title of the plaintiff, and it has got presumptive value. He has relied upon the judgment passed by Honorable Patna High Court, reported in AIR 1997 Patna 124, paragraph 28, and he further submits that it was not in dispute that such entry was made in record of right, and Dayal Kumbhar was in possession of the property as advertiser, but it was a case of the defendant that he had surrendered the property in favor of the landlord, but the surrender having not been proved, the cloud with respect to the title of the plaintiff was no longer existing, and therefore the appellate court ought to have decreed the suit. He submits that both the questions of law are fit to be answered in favor of the appellants, and an appropriate order be passed decreeing the suit. That's all. The Learned Counsel appearing on behalf of the respondents has opposed the prayer and has submitted that and has referred to the judgment passed by the Honorable Supreme Court, reported in (1997), Volume 7, SEC 435, and has specifically referred to paragraph 19 to 21 of the same judgment to submit that there was no need to challenge the finding with regard to the surrender, and by filing any cross objection, and the same could have been asserted by the defendant in the appeal filed by the plaintiff. He submits that therefore the first question of law is fit to be decided in favor of the respondents. However, during the course of argument, he has not been able to show any material from the records that the finding in connection with the finding of the Learned Trial Court that the defendant could not prove surrender was agitated before the first appellate court. The Learned Counsel has further submitted that the law is well settled that the plaintiff has to prove his own case, and his case cannot rest on the weakness of the case of the defendant. For this purpose, he has relied upon the judgment passed by Honorable Supreme Court, reported in bracket 2014, bracket close to SCC 269, para 12 to 15, and has submitted that in a suit for declaration of title, burden always lies on the plaintiff to make out and establish a clear case for granting such a declaration, and the weakness of the case set up by the defendants would not be a ground to give any relief to the plaintiff. the learned counsel submits that such argument assumes importance in view of the fact that the defendant had throughout remained in possession of the property and the rent receipts were issued in their favor after vesting since the year 1954. The learned counsel has also submitted that Chaukidari rent receipts were also issued prior to vesting. He has further submitted that, however, during the course of argument, the learned counsel has fairly submitted that so far as zamindari rent receipts are concerned, the same has not been produced by the defendants. Correct? The learned counsel has also relied upon the judgment passed by Honorable Supreme Court, by this court, reported in 2004 within bracket 3 ACR 662. And has paragraph 16 to submit that there is a presumption of correctness of 30-year-old document. In the present case, Hukumnama was a 30-year-old document and therefore the same was required to be accepted as valid by reference to section 90 of the Indian Evidence Act. He has also relied upon the judgment passed by the Honorable Supreme Court reported in 2024 Supreme within bracket SC 1065 para 8.2 to submit that the entries in record of right does not create or extinguish any title. Those are, the title is to be proved by producing appropriate documents. That's it.
And the rent receipt is a strong evidence of possession.
The rent receipt produced by the defendants is strong evidence of possession. The learned counsel has relied upon the judgment passed by the Honorable Supreme Court, reported in bracket in 2007 within bracket 3 JLJR 308, and has referred to paragraph 13 of the judgment to submit that the entry in record of right to submit that Register 2 is a document maintained by the circle officer and these documents only show strong evidence of possession. He has also relied upon the judgment reported in 2004 3 JCR 292 para 11 in support of the same proposition that entry in record of right is not a document of title at all. In response, the learned counsel appearing on behalf of the appellant has referred to the findings recorded by the learned trial court and has submitted that the learned trial court had also disbelieved the rent receipts issued, had also doubted the correctness of the rent receipts produced by the defendant in view of the fact that when the document, when information was furnished from the circle officer by Exhibit 4, by Exhibit 4, no entry was found in the column in Register 2. The learned counsel submits that the Register 2 maintained by the state did not record the rent receipt having been issued in favor of the defendant. Rather, it did not say that the property was running in the name of the defendants, and therefore the rent receipt as well as the hukumnama was disbelieved by the learned trial court. He submits that this finding also attained finality, and there was no challenge or argument with regard to such findings recorded by the learned trial court. That's all. ये जो appellate court जो एक finding दे दिया है यहाँ पर has not been able to either prove his title or possession. Even this is a submission, this is a finding. I find on factual aspect from the oral and documentary evidence that the plaintiff slash appellant has not been able to prove either his title or his possession even on the basis of. So there is a finding in connection with possession so far as you are concerned. During the course of argument, it revealed that in paragraph 25 of the trial court judgment, appellate court judgment, it has been recorded by the learned appellate court that from the oral and documentary evidence, the plaintiff slash appellant was not able to prove either his title or possession even on the principles of preponderance of property.
That I am assailing on the ground that entry in the record of rights shows Kaimi. Kaimi is permanent settlement.
He submits that such finding has been recorded, although the entry in record of right was showing permanent settlement, and the aforesaid finding has been recorded on the basis of Banda Pacha.
Yes.
Yeah, na?
Huh.
We put a date for your judgment. कल का भी डेट नहीं पड़ा है ना? कल भी एक केस का डेट पड़ा है। कल का केस का नंबर क्या है? ये वाला CR14 ऐसे ये वाला नहीं, इसमें तो डेट ऑफ जजमेंट
सेकंड है तो 304 सेकंड है तो इसमें नहीं है
304 इसमें नहीं लिखे हैं ना 304 और सेकंड ये इसका क्या नंबर है? इसका नंबर कितना है? ये वाला केस का नंबर 240 we put a date for judgment. CAV करने से वो एकदम out of sight हो जाता है.
There is one request with respect to item 1 in daily causes. Can it be on Tuesday once? I will inform the other sides. I have a feeling for the other side.
आज से थक गया मैं और अभी
Pass over हो गया केस. It happens because in court 13 I have taken time in 1 second appeal for this reason.
for this case.
Since he has difficulty, personal difficulty, he cannot object. Whenever it is convenient, it is on
You want it on Tuesday?
Tuesday.
So
Monday is
number
holiday.
1 put it at the joint request of the learned counsel for the parties post this case on Tuesday.
Ladyship, may I mention two matters? Just next matter, Ladyship, serial 22 and serial 29. I have to leave for some personal difficulty, if possible next
You are the
week.
appellant?
Yes, I am from the appellant. I'll inform the other parties as
You
well.
will inform the others, eh?
29, I am appearing for the respondent.
28 and 29.
No, 22 and 29 I am paying.
22. Any
22 is
objection?
the next
She
one.
has got some personal difficulty.
None.
Sir, pass over for the date. We are
Yes,
not
sir.
recording any
Yes, yes,
order.
yes.
अब सब लोग खड़े हो गए टाइम मांगने के लिए.
Then,
अब किसका है? अब किसका मैटर है? पास ओवर किए थे? हाँ. आप तैयार है ना? एक मैडम वाणी कुमारी का मैटर था. You are ready? We will hear it. आप रहिए थोड़ा शाम तक. I do not know कब होगा.
Your Lordship,
छोटा सा मैटर है आपका तो ज़्यादा हैवी नहीं. It's a very small question.
in serial 17, Your Lordship, I was only playing the matter will be posted in the next week.
ऐसा नहीं है. पास ओवर हुआ है ना.
But it was on account of last indulgence for removing the defects.
अच्छा. दिखाई दे. रिकॉर्ड पढ़ना पढ़िए, ये पढ़िए उसके बाद नेक्स्ट पेज। प्रॉब्लम क्या है कि आजकल आप लोग को रिकॉर्ड पढ़ने के लिए तो टाइम नहीं मिलता है। किस हेडिंग में लगा है?
और hearing
नेक्स्ट पेज में पढ़िए। Is it for removal of defect? झूठ बोलने का ये बहुत
Your
बड़ा
Lordship,
defect।
my senior has stated that we took
आपके
time
सीनियर
for-
से मत चलिए भाई, क्योंकि कोर्ट को फेस आपको करना पड़ता है। आपकी ये ऑर्डर्स अपलोड नहीं हो रहे हैं। यस, आप लोग तो नया जनरेशन है, आपके पास तो एनी टाइम जो मोबाइल में जो पीछे बैठ के पिक्चर देखते रहते हैं, थोड़ा सा ऑर्डर शीट देखा करिए पुराना, कुछ भी सबमिशन करते हैं। कहाँ कौन है आपके सीनियर जो बोले डिफेक्ट में? उन्हीं को बुला के लेके आएंगे, ही विल कंफर्म कि उन्होंने आपको ऐसा बोला। कौन है आपके सीनियर?
अभिषेक कुमार।
हाँ, बस उनको बुला के सेकेंड हाफ में बुला के लेके, नहीं तो 10,000 रुपये कॉस्ट तो आज हम छोड़ेंगे ही नहीं। आप रिकॉर्ड में इतना वीक कैसे रहते हैं? फाइल पढ़ने में, रिकॉर्ड पढ़ने में इतना वीकनेस क्यों है? You may be, we may be wrong in law, but how can we be wrong on facts? आइए सेकेंड